Your Lordship, item 60.
Yes.
Your Lordship, item 16. Can it be taken as a first item because I have some medical appointments?
Item number
Item number 16.
15. Okay.
Of like.
It's regarding item number 11. We want to withdraw this petition. Your Lordship. Item number 11. Your Lordship.
Your name?
H. Your Lordship.
So withdraw. Into order you can use. In order to make it again.
Lordship.
I don't have any number one bench. So all the benches are there. I'm neither taking a bench 1, a bench 4, bench 5, bench 3. All have other judges. I'm only taking the second bench mentioned there.
Ma'am, please, Your Lordship. Lordship, back to mention item 25, Lordship. Lordship, the petitioner in this case, Lordship, died, Lordship. On 30 September this year, Lordship. I have to obtain instruction, Lordship, whether the petitioner will be substituted by his legally or not, Lordship. 4 weeks time, maybe that the petitioner died.
Wait. What is the matter about?
Lordship, the matter pertains to non-payment of contractor's fee. The petitioner died on 30 September, Lordship.
The request of the learned counsel for the petitioner matters tangent to be listed after 4 weeks.
Deeply obliged.
Huh? To be taken up? Why?
May I please, Your Lordship?
Not 2. We'll take it up as the last item.
May I please, Your Lordship? I'd like to mention WBC number 3837 for listing.
Why?
Matter pertains to, as per agreement, interrelated to hospital green. As per agreement, I was supposed to take in a charter special flight, but I was taken in a ordinary passenger flight, my Lordship.
Huh?
As per agreement, I was supposed to take in a charter special flight, but I was taken in a ordinary passenger flight, my Lord.
Now what do you want?
My Lordship, I want my money back, but as per agreement, I was supposed to take in a charter special flight, my Lord.
That I know. Now what do you want now? You want the matter to be listed.
Yes, my Lord.
It will be listed in the 2nd week of December.
My Lord. Deeply obliged.
Huh? The request of the Mr. S.S. Roy, the learned counsel for the petitioner, matter stands adjourned to be listed after. There's an interim order to be listed again 6th of January 2025. Interim order passed earlier shall continue. Till then.
For withdrawal, item number 52.
I have instructed to not.
Withdraw. Interim vacated.
Item 16.
What is this?
If your Lordship just go through this petition. So at para number 3, if your Lordship may just see one, that the petitioner here in this case, he was being served a 41A notice by the police for a complaint. The complaint is at page 8. If your Lordship may just allow me to read. The typed copy of the complaint at page 8.
What is this type of repetition?
I will say, clarify your lordship.
Hmm.
So what happened at page 8? As per this complaint, the petitioner was served a 41A notice when this entire lockdown was been going on. Simultaneously, he appeared before the police station. He was kept in the entire night till 12:30, and then he was allowed to go. Simultaneously, after 3-4 days, the police started coming, visiting to the petitioner's house, and then calling him at any time to go and appear in the police station for everything. After simultaneously passing off minimum 10-15 days, the petitioner was again served a 41A notice for some another case, which he don't even aware of. Even in this present case, the complaint for which we are coming before this court, even in this complaint, the petitioner is not named in the FIR.
Then
So therefore, we are just wanting before this court that due to the infringement of the personal liberty, that necessary disciplinary action is required to be taken against those officials.
who are you? Who are you? The petitioner, who is he?
The petitioner has been called by the police officials for a matter in which he is not even been named. If your lordship may just go through this entire typed copy of this FIR, know where the complainant name is there. And simultaneously, if your lordship may just see the affidavit filed on behalf of the police.
Yeah, charge sheet given.
That is barred by against section 319 of the CRPC. The person who is not even named in the FIR can be tried for an offense, but with due permission of the court.
That we will look into it. First of all, has the charge sheet been given? Get your instruction.
Now, your lordship, just for an while, if your lordship may just pursue the affidavit once, only at page 7, the affidavit which has been filed by the OC, officer in charge, at page 7. That's the 6th line of page 7 in the affidavit.
Yeah.
It says the humble deponent begs to reiterate that the notice issued for appearance on 1/4/2021 before the IO was in connection to the Jalukbari PS case number 333/2021 and not for PS case number 331/2021. As inadvertently mentioned in the said notice, it is further reiterated that the PS case number so-and-so was inadvertently written as so-and-so by hand, and as such, the humble deponent begs to submit that the same was a clerical mistake on the part of the IO. So what is this, your lordship? First they slap and they say that it is sorry. It's the
kindly come to the next. Further, the humble deponent begs to state that although the
that
petitioner's name is
state
not
that though the
reflected in yet
petitioner
during the
name is not-
investigation, so-and-so, the involvement was revealed to the extent that the accused so-and-so along with the had gone to the Makulma and sold the subject vehicle by an agreement executed for sale. Let
Now,
us,
if,
we'll
now
see.
if the agreement
No.
is there,
Kindly listen, we'll ask, take instruction as regards whether the charge sheet is. Yeah, your name? Mr. G. Bukuli, the learned PP. The learned junior government advocate shall obtain instructions and place before this court on 2nd of December 2024 as to whether any charge sheet has been submitted pursuant to the investigation carried out in respect to Jalukbari PS case number 333/2021. Huh? We are concerned with 333/2021. I don't want 331. 331 is inadvertent. I'm asking about 333 of 2020. It's recorded.
so your lordship may just fix this matter after 10th of December because from 1 to 5 I will be in the Supreme Court.
I'm having it on 9th of December.
Then it's fine. Obliged.
Item number 1, order no steps.
9th of December. Huh?
Lordship, we are not pressing this matter, Lordship.
Steps taken? No.
We are not pressing this matter, Lordship. Matter is in fact.
You are? Counsel appearing on behalf of the petitioner submits that the petitioner has, that she had been instructed not to press the instrument. Accordingly, the petition stands closed on withdrawal. Full stop. Interim order. Any stands vacated.
Similar prayer, Lordship. Similar prayer.
Same.
Majority.
3,
And appears on behalf of the petitioner of Bob. It is noticed that on the earlier occasions also the petitioner is not present. Which, taking into account the above, seems that the petitioner have lost interest in the petition for which the petition stands dismissed on prosecution. Interim orders, if any.
order for
Please, Your Lordship. Well, in this case, my lord, I had filed, my lord, two in this case, my lord, I as my lord. One is,
Who is the petitioner?
I am for the petitioner. my lord.
Your case?
I filed, my lord, two I as my lord for impeachment of the writ petitioner, my lord. He is no more, my lord.
Huh?
The writ petitioner is no more, my lord. His legal heirs as well as his brother and nephew, my lord, who have been impeded in IA number 3407, my lord. And my lord, I could not submit.
আয়ে কি এখন আছে? কোন আয়ে? Yes, what are these?
My lord, the death certificate, my lord, pertaining to the death of the petitioner, my lord, that I could not annex, my lord, in the IA, my lord. Therefore, my lord, I was directed by this honorable court to file one additional affidavit. Now, my lord, I have filed one additional affidavit.
Why there are two ayes?
My lord, in other IA, my lord, also, my lord, the private respondent, my lord, he is also no more, my lord. The private respondent number 4, my lord, he's also no more, my lord. Therefore, my lord, two IAs, my lord. The implement, my lord, have been made, my lord, in both the IAs, my lord. For implement of the writ petitioner as well as the implement of the, my lord, legal heirs of the, my lord, private respondent number 4 also. Lordship will kindly deal with the 3407 IA, my lord. Flag mark A, my lord, the death certificate is there.
IA 3407 of
34.
2024.
Yes, my lord. Page 11 is the death certificate.
This is an application filed for substitution of the legal representatives of the petitioner who expired during the pendency of the instant writ petition. it is seen from the records that the petitioner expired on 16/8/2022. Further to that, it is also noticed that the petitioner hearing that the petitioner survived by what was the name of the petitioner?
Name of the petitioner is my lord
Khaled.
Abdul Khaled Khan alias Abdul Khaled.
The applicants to the instant application. The applicants number 1 to 7 of the instant application. Accordingly, this court, taking into account that the cause of action survives upon the death of the original petitioner, substitutes the applicants number 1 to 7 against the name of the original petitioner. This court, however, makes it clear that the applicant number 8 and 9, being not the legal representatives of the original petition, are not substituted. The counsel, the counsel appearing on behalf of the applicants number 1 to 7 are directed to file a fresh memo of parties before the registry of this court within 7 days from today. The registry shall, on the basis of the fresh memo of parties as well as the instant order, substitute the applicants number 1 to 7 against the original petitioner and make necessary changes in the cause title, as well as also update the same in the CIS. Not 8 and 9. How do you make 8 and 9?
My lord, in the writ petition, my lord, which was filed, my lord, in the year 2020, my lord, I have clearly stated, my lord, that the land was, my lord, sold to be his original own brother.
That is a different thing. That will be another application. You are to bring a separate application. You can't file this type of application of own brother. Now, own brother cannot be a legally representative.
Since the, my lord, writ petition was.
Mr. Counsel, you have to understand little bit of law
My lord,
before making this type of
I'll file,
application.
my lord, another.
You don't make everybody a party on this. First of all, what is this implement application?
File,
How many years of practice?
my lord, 14 years.
14 years you don't know
But I know, my lord.
that there is a requirement of a substitution application.
Yes, I'll file,
Then what is this?
I'll file.
Next one letter. IAC 3408/2024. The instant application has been filed to substitute the legal representatives of the respondent number 4, who expired during the pendency of the petition. It is seen from the materials on record that the respondent number 4 expired on huh? 6th of February 2021. As informed by the earlier counsel representing the respondent number 4 by Sri so-and-so. Taking into account that the right to sue survives upon the legal representatives of the respondent number 4 the opposite party numbers 4 to 9 herein are substituted against the respondent number 4 and arrayed as respondent number 4A, 4B, 4C, 4D, 4E, 4F, respectively. The G ratings. Abhishek, the counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days. And on the basis thereof, the registry shall make necessary corrections in the cause title of the writ petition and also update the same in the CIS. IA stands disposed. A main writ petition or petition, issue notice upon the newly substituted respondent numbers 4A to 4G by registered as well as by usual. The petitioner is directed to take steps by within 3 months.
I'm deeply aware.
Notice making it returnable on 8th of January. Interim order passed earlier shall continue till the next.
Item 54,
My applicants herein are the newly elected board of directors from applicants 10 numbers. 1 to 10. Pursuant to the, my lord, filing of this writ petition, my lord, petitioners are elected as board of directors, my lord. So far as the decision of the writ petition is concerned.
Who is the writ petitioner? Writ petitioner? What is it challenging?
My lord, this challenging the, my lord, order passed by the register, whereby, my lord, register is directed. Worship kindly see order at main writ petition, my lord. At page 38, my lord, in except 12.
What is wrong with this order?
My lord,
What is wrong with this order?
my lord,
Who are you?
I am the board of directors, newly elected board of directors, my lord. After filing of the writ petition, my lord, we are elected, my lord. On
Then what do you have?
24th, on 19/2/2024, my lord, we are elected to the board of directors.
Lemi Mondol, where is he?
My lord, their names are shown, my lord. While filing the writ petition, earlier board of directors were made parties.
Earlier board of directors,
They have
as
nothing
on
to-
that
they-
date,
they are
had
already,
already
my lord,
nothing.
dissolved
to do.
parties, my lord. Dissolved members.
This is the area, na? Kochim Mondia SS.
Yes,
That is it.
yes.
It is already a party.
My lord, not,
By
my
one
lord,
man.
board of directors, my lord, pays three, my lord, my
Where
application.
is Mr. M.U. Mondal? We should dismiss his petition. Then why do you require other things? The application becomes infructuous. Where is he? Hello, we dismiss his petition as non-appears. Why do you need to be a part? So many lawyers, their names have not been shown.
Then it's shown, my lord, in the post list. my lord.
Then, where are they? Get hold of him. I think this is the fit case for dismissing. One-man committee was appointed.
Yes.
Then,
Then, my lord, election was held and the present applicants were elected on 19/2/2024 by holding AGM stroke
it's
election.
okay. I'm directed to state that the register has fixed. Why was he suspended? Has been appointed temporarily of so and so by the HCRS, which is not as per law. As per 32 remand, the board of directors is empowered to nominate, elect or appoint a in view of the above and yes, where is Mr. Mandal? Come here. Mr. J.M. Choudhury, come here. Let us dismiss his petition. Yes, what case you have?
But they have filed an IA.
Forget about the I. What case you?
My lord.
What is your case?
My case is, my lord, since, my lord, the board of directors have, my lord, appointed
How
me
were you appointed?
by the board of directors.
When?
Yes.
Let us see your appointment letter. Yes.
My lord, can it be, my lord, taken up day after tomorrow, my lord?
No. Now. Where is your right? What is your right? How were you have resigned? You have resigned?
Yes.
Then what happened?
He has resigned as a member of the board of directors.
Then
Then he has been appointed as a secretary.
where is your appointment letter?
Yes.
Show me that.
My lord, main petition file is, my lord, not
2
available.
o'clock. 2 o'clock.
2 o'clock. My lord, can it be tomorrow, my lord?
2 o'clock.
This
Tomorrow
file has
is-
not come, my lord.
Tomorrow no. 2 o'clock.
At least, my lord, tomorrow, my lord, so that
2 o'clock. Have a file. My second file. All these files. Mr. J.M.A. Choudhury, your case is now you are the board of directors, so you will be appointed. So that is what.
For admission item 4,
Then what happened?
The last occasion, submission was made by the proposal from the health department is lying before the standing finance committee. The committee has not recommended it. Lying down. The issue will take up with the committee on Friday. Standing committee has recommended the.
It's a big way. I don't understand a very pertinent question. What is this standing committee approval? What is this? Means you take somebody's land and then you don't have any foresight or what? There's something. You can't take any decision without the finance. How did you acquire the land then? At the first instance? How did you acquire this land? It was requisitioned in 83. Then I did not want to disturb the status quo. Therefore, I permitted you to go for an acquisition. Otherwise, it was on the face of it, expressly illegal. Everything was illegal. So, couldn't that be a violation of Article 300A? And Article 300A, wouldn't it supersede the provisions of the Land Acquisition Act? More particularly when it has been held to be a constitutional right. See the judgment of the Supreme Court in the case of state of Himachal Pradesh versus Mastram, reported in 2024, SCC Online 2598. Let us read that paragraph. Why we should not say that you should pay that amount along with interest now, within 7 days, 15 days? The Supreme Court says that time is the essence in determination and payment of compensation is also evident from this court's judgment in Kupreza Construction Company, wherein it has been held that once the compensation has been determined, the same is payable immediately without any requirement of a representation or request by the landowner, and a duty is cast on the state to pay such compensation to the landloser. Otherwise, there would be a breach to Article 300A. In the present case, the government of Himachal Pradesh as a welfare state ought to have proactively intervened in a manner with a view to ensure that the requisite amount towards compensation is paid at the earliest. The state cannot abdicate its constitutional and statutory responsibility of payment of compensation by arguing that its role was limited to so and so. Acquisition of land for public purpose is undertaken under the power of eminent domain of the government, much against the wishes of the owners of the land which gets acquired. When such power is exercised, it is coupled with a bounden duty and obligation on the part of the government to ensure that the owners whose land gets acquired are paid compensation awarded amount as declared by the statutory award at the earliest. The state government in peculiar was expected to so and so. So therefore, the direction was the respondent number so and so are directed to pay the compensation amount of so and so along with 9% interest thereupon from the date of passing of the award dated till the date of realization within a period of 15 days from today. The amount paid by year shall be we dispose it of, directing you to pay with interest at the rate of 9% from the date of the award. When is the award passed? I have it. No. That is enough. This card, he is entitled to interest now at 9%. Now you will realize with 11 crores and interest goes out there, then what happens? You have taken this thing for granted. Yes, Mr. When was the award passed?
Initial award was passed in 96/8/81.
6th of August, 1981.
When?
6th of August, 1981.
No, no, award.
But that award has still not been passed. That award has not been passed.
So you don't have an award.
They don't have an award.
Oh, without an award, the land is yours. So obviously, we hold it back. Return it. Whatever it will, go and file appeal now. You don't have an award today. Return the land.
That's what the new.
No, no, nothing new. You don't need to pay earlier, but this is how it is. Absolutely. We are not concerned. This is the constitutional obligation. And if you have not passed an award, nothing remains. So it is very good. We pass the order immediately to the effect. Acquisition of the possession is illegal. Hand over the possession immediately. Give it back. How can it happen every time? Every time this is happening. First of all, you have tried to appropriate the land of the petitioner by making it your land without any due process. First, you go for, luckily, he had one document which shows that it was a requisition made. Then when we catch hold of the revenue authority then makes a correction, makes a pratta, again issues a fresh pratta to him. This is how you are doing it. Tell your officers that I'm going to pass this order on Thursday. There's nothing out there. I'll say that this is not done. It is in violation of 300A to hand it over back to them. Immediate. Quick. Because the state cannot be permitted to act as, what is the word to be said? What the state is doing. You can't requisition, which I held it to be bad at that point of time. The state cannot be, it is a case of judicial overreach, which you have taken. This can't happen. It has been submitted by Mr. B. Gogoi, the learned planning council of the health department, that the standing finance committee have already approved, and that the estimate would be is likely to be approved during the course of the week. He therefore submits that let the matter be again listed on 29th of November 2024. It is seen from the reports that the land of the petitioner have been taken by the respondent authorities. There is neither any award passed nor any payment have been paid to the petitioners. In terms with the judgment passed by the recent judgment passed by the Supreme Court, in the case of Ultratech Cement versus Mastram and others, reported in 2024 SCC Online SC 2598, it is clear that non-payment of the amount after the compensation has been determined immediately results in breach of Article 300A of the Constitution. Taking into account that the health department is going to take appropriate steps for clearance of the amount as submitted by the learned counsel for dispersal of the amount as submitted by the learned counsel for the health department. This court fixes this matter again on 29/11/2024. I'm not going. Is approval.
Right now.
Item 5, part third.
Yes, what are you doing? Were you?
Well, I have received the copy.
What is he doing? What is your stand? Give a copy of it. No, you can't impose upon them this way. You can't impose upon them this way. This is the zonal values. If you have to acquire, you have to, if it is a case of acquisition, it will go with a solution of 100%. If it is if it is a case where it falls under the rural area, then obviously it will come to twice that amount as per 26(2). So you can't say that you are going to buy at 25 lakhs. I'm not concerned with big area. If you are purchasing, you purchase at his rate. Or you have to acquire. Either of it. So you go as per the acquisition rates. Go for acquisition rates. No. Therefore, you cannot say, Mr. Singh, kindly appreciate. If you are going to purchase from him, you purchase at his rate. This court can't impose upon him to sell it at any other rate. He may quote tomorrow 10 crores also. So you may have the options of going for the purpose of acquisition. You can't come up with this type of thing to the effect that we are going to purchase at the rate of zonal. He may not sell you at this rate. He will sell it at whatever rate he feels like. More particularly, when the court is taking over the matter, he will obviously have a more higher bargaining power. He will do so. So therefore, your question is, how do you do it? You should have done it by now. Don't make him more clever. When the matter comes before the court, I try to make more clever the petitioner. Have a discussion, do whatever you like. Great. Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI had submitted. Did you get the some money which was there
Well, at that time, yes.
from the DC?
Yes. Technician.
Submits that that an additional affidavit has been filed by the FCI. The registry shall bring on record the said additional affidavit. List this matter again on 16th of December 2024. You better talk out and do something. Otherwise, this is not going to solve it. Why not 16? 17? Item
6,
May I please, your lordship. This matter relates to allotment of land for brick industry. Your lordship last occasion asked me to furnish a copy of the order. My lord, this matter relates to allotment of my lord land for brick industry. And your lordship has passed similar order. Your lordship asked me to furnish the similar order. Last occasion.
Here and Lordship, in the other cases, there was an agreement.
That is-
Agreements. But in this present case, There is no any such agreement.
That is
What
correct.
your lawyer directed us, and therefore, there in agreement thereafter. In our affidavit itself, in paragraph 4, we have specified. Other cases, your lordship has directed as because there is an agreement without cancelling two agreements cannot take precedence. So the land under by applying 18. As there is no such any agreement accordingly. The director of complaining. Whether is there any agreement. But in our affidavit, typically it says that there is no such agreement.
The difference was that so we have an allotment and they have agreement also.
Thereupon, why did you collect the royalty for him? The communication dated 16th of November 1995, Annexure B, would show that you have specifically given him 20 bighas of land for a period of 3 years. This is as per your land policy for the purpose of bricks.
Beyond 3 years,
Beyond 3 years, so he was to hand over, you are requested to hand over the possession of the land to the persons concerned on realization of the royalty in full. Now, why you have been taking the royalty thereafter? So under such circumstances, can the circle officer and not the revenue department which permitted him to enter
then you say. There also the working deposit is taken royalty as well as revenue.
they have not deposited?
Last week, my lord, your lordship kindly see the case 46, 47, and 49. The 26, 27,
From
revenue
1993 till 2007. Your lordship for affidavit.
46, 47, 49. Last.
Sir, 1990, 2017, they have not paid. Thereafter, in 2017, they have approved the honorable court and they have deposited the royalty. Okay.
When was the notice issued?
It's 53, man.
Hmm?
24, 170,
24,
170.
1, 2017.
Seven.
Now, what do you say about page 50?
It is the revenue receipt plus royalty on 3/12/2016, page 49.
for the year 2016-17. What about the earlier period?
Earlier period of this not annexed.
You
And
have it?
their affidavit is that we are defaulter. Like,
Huh?
we are defaulter.
You are defaulter?
Their affidavit says so.
Then, if you are a defaulter, then obviously you have not paid.
Yes.
Then-
It is their affidavit.
So have you replied to that?
No, that is not.
Then how do we help you? We could
Fine.
not.
That is, that instruction we don't have that for for last years we have paid or not. That is not. We have. Last I have. Suppose that is before impugn order. Royalty has been paid before impugn.
Understood, but only for 1 year. What
But
about the earlier
For
period?
earlier year, we have record.
Because your period ended in 98.
Yes,
Thereafter, did you make any payment?
correct. That is correct.
Huh?
That is correct. But we have actually no contact with my clients. That is, we could not collect those documents that whether royalty has been paid or not, the revenue has been paid for subsequent years or not. That is my problem. Yeah.
98.
No, 1993, 1950.
1990. Time of.
Up to
No, his allotment was given in 95. Then why will he pay prior to that? Huh? So after 98, where your statement?
They have received the notice in the month of January 70. They have paid the royalty in the month of February and they have.
No, here it says, affidavit says about 93. Why does it say about 93 when the letter is saying about 95? Huh? What is this letter, affidavit? Yeah, affidavit doesn't seems to be, because those other matters were 93. You must have copied and pasted. I think this must have been what you have done.
earlier.
Let us catch hold of this assistant commissioner who has filed this affidavit in such a manner without taking into consideration. Because in these cases, it is 93, Mr. Sharma. So you have just copied and pasted, whoever has filed this. I think you file a better affidavit. What do you say? Huh? Because this is what you have stated. Kindly come to paragraph number, paragraph 4, the second portion, page 2.
Pertinent to make it.
The matter has caused delay to event the district authority manager delivered advance possession of the AR by letter dated demand which was delivered to the division demand. In great financial loss with effect from demand. Copy of the possession certificate dated so and so and so. Let's see annexure 1 and 2. So this is being given 95. And the possession was given when? Possession was given even prior to allotment. Hmm. No. Where's your statement that they have not paid?
Page 2, third paragraph.
Page?
It's our third paragraph. Last line.
Oh, you have not. Shall. Heard Mr. and Hawk, the learned counsel, appearing on behalf of the petitioner, and Mr. H. Sharma, the learned counsel, appearing on behalf of the district administration, and Ken Woodley, appearing on behalf of the Revenue Department of the Government of Assam. The petitioner herein have essayed the initiation of proceedings for eviction by the notice dated 24/1/2017 issued by the Circle Officer Bagbor Revenue Circle. So far, it relates to the plot of land measuring 20 bighas covered by Dag number 235/4 AA of Hatkuchi village under Zanila Moza in the Borpeta district. From a perusal of the materials on record, it is seen that the government of Assam had made a land policy in the year 1989. In terms of the land policy, and more particularly in clause 8.1, it was envisaged that temporary permission for use of government khas land for manufacturing brick, tiles, etc. may be given not exceeding 10 bighas in case of individuals and not exceeding 20 bighas for cooperative society or firm, subject to execution of undertaking by the permit holder to the effect that he would pay in advance the land revenue of the land and the royalty as fixed by the government, and would vacate the land after expiry of the term not exceeding 3 years. First, it is also mentioned in the said policy that the term of permission would automatically stand terminated at the end of 3 years. In pursuance to the said land policy, the petitioners applied for allotment of land on behalf of MSDND Enterprise Brick for a period of 3 years. The record reveals that in the year 1993, possession was handed over so reveals that on the basis of a letter dated number 97/93/2021, dated 25/11/1993, the possession was handed over to the petitioner on 21. Possession of 20 bighas of land was handed over to the petitioner on 21/12/1993. It is, however, very strange to note that without even any formal letter of allotment, such possession was handed over by the Deputy Commissioner Borpeta. Be it as it may, the record further reveals that the said aspect was regularized by issuance of a communication by the Deputy Secretary to the Government of Assam Revenue S Department to the Deputy Commissioner, whereby land at measuring 20 bighas covered by Dag number 235 of Bhatkuchi BGR under Jonia Moja was handed over, was allotted to the petitioners on behalf of MS DND Enterprise bracket Brick for a period of 3 years only on realization of the royalty as instructed by Government Circular dated 26/5/1986. It was also mentioned in the said communication that the land be handed over to the persons concerned on realization of the real royalty in full. Be it as it may, it is further apparent from the perusal of the pleadings that perusal of the affidavit filed by the respondent number 2 that although the land was handed over on 21/12/1993, but and the same was regularized by the communication dated 16/11/1995. But the petitioner neither entered into any lease agreement with the government nor deposited any royalty amount. It is also very pertinent at this stage to take note of that the lands in question are VGR lands, wherein such settlement, such allotment for being used as a brick industry was not at all permissible, taking into account Rule 95 of the settlement rules, as well as also the judgment of the Supreme Court in the case of Jakpal Singh versus State of Punjab, reported in 2011. Be it as it may, the petitioners continued to enjoy the land without payment of any royalty or even any land revenue. It is only said that in the year 2016, for the first time, the petitioner paid some amount of, in the month of December 2016, the petitioner paid certain amounts towards royalty for the period from 2016-17 and also paid certain amounts on account of land revenue in the year in the month of January 2017. It is also relevant to take note of that for the period from 1993 to 2015, the petitioner did not make any payment, as is evidence from the affidavit filed by the respondent number 2, to which there is no reply so far. In the backdrop of the above, this court had heard the learned counsel appearing on behalf of the petitioner as well as the respondents. The learned counsel appearing on behalf of the petitioner have laid emphasis on a judgment passed by the ordinance by this court in the case of Bonjit Bormon and others versus the state of Assam dated 6/11/2024, whereby this court held that the initiation of proceedings, summary proceedings under Rule 18 of the settlement rules was not permissible, taking into account the land was allotted to the petitioner therein. Mr. Ironhawk, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner stands in a similar situation, and as such, the petitioner should also get the benefit of a similar directions. This court had duly perused the judgment passed in Bonjit Burman Supra, wherein it was a specific case that pursuant to the allotment so made, the petitioner therein had entered into a lease agreement. It was also seen that from time to time, the petitioner therein had also made the payment towards the royalty, as well as also the land revenue. It is under such circumstances, this court had held that the initiation of the summary proceedings under Rule 18 of the settlement rules was not permissible. However, in the instant case, it is seen that there is no agreement. It is further seen there is no lease agreement entered into. It is further seen that the petitioner herein had not made any payment towards land revenue or towards the royalty for the period from 1993 to 2015. Additionally, it is also very pertinent to take note of that the land wherein the petitioner was handed over the possession in the year 1993 is a VGR land, which, as per the provisions of Rule 95 of the settlement rules read with, the judgment of the Supreme Court in the case of Jakpal Singh could not have been allowed to be used. Under such circumstances, this court does not find any merit in the instant proceedings to interfere with the notice dated 24/1/2017 passed in the eviction case number 1/2017 by the Circle Officer Bagbor Revenue Circle, insofar as the plot of land measuring 20 bighas of land, 20 bighas covered by Dag number 235-4 of Bhatkuchi village under Jamila Moza in the Borpeta district. Accordingly, the writ petitions being devoid of merit stands dismissed. The dismissed interim order posterior stands repeated.
Item 7.
Please, your lordship. Lordship, this matter pertains to the claim of ex gratia by the old age lady my lord.
Yes, BTC. Yeah, BTC. Where's BTC?
My lord. The petitioner.
Oh, did you submit the
Yes, my
document?
lord, already provided the signatures, my lord.
You have provided the
Yes.
signature. When?
My lord, exact date I don't remember, my lord.
Exact date you don't remember or you did not ask?
My lord, was forwarded on 4/11/2024. 4/11, my lord.
So you have submitted, na?
Yes, sir.
None appears on behalf of the BTC on call. For the ends of justice, list this matter again on 29/11/2024.
Keep your blood.
Okay.
Oh, this is a sealing case, my lord, that my lord has ordered to bring the records on 23/9/2024, my lord.
Yes. Is it 136 or 163? 1263. Huh? 12636. So not 1263. No, not no. So your land is 1263.
1236.
So this needs to be corrected. One, two, three, six. 236 has become 3890. What are your name?
One.
Name?
At 1236, my lord.
That is their name, sir.
Yeah, my lord.
Not.
Yes.
There's been made so card.
3 Devi Surana. 3 Devi Surana. At 6, my lord.
1236.
Real number
big
6.
job, huh? Well done. Get Sita. Get the Sita. About you get the ceiling surplus
Ceiling.
case number. 5. Isn't it?
Sealing, yes, my lord.
Because there, the question is, here there is no record of 1263. Your land is 1263.
1236.
And then affidavit properly on the basis thereof. Say that his land is nothing to your case, Mr. Of land measuring it. Six is government land, but what is your land?
No, that has been made government, my lord, now, from 2009 onwards, after resettlement operation.
Ah.
Now, earlier, my lord, it was 1236, the original dark, my lord. So, in the order column, where the circle officer passes some order, Assamese is called hukum, in there, the dark number is intact, 1236, no land has been, deleted. As per our Domabundi copy,
So that you see, for him that. What is your name?
Sri Devi Surana.
Kumar Surana.
My mother's name is inserted, Sri Devi Surana.
Regarding the profile.
Your land is where? What is your land? Pacheya, it is 1236.
1236,
So your land is also 1236.
Yes,
And that is 2 bighas.
2 bighas.
Your land is 2 bighas.
Yes, consolidated 2 bighas.
So of 1236. Now, can you see there in that book? Okay. How did it become Sarkari?
Regarding the blocking of the ceiling surplus. We have to see. Fine.
That's the problem. How did it become Sarkari means it has to be somewhere because here, you see, can you see? 1236. 1236 is a very big dam. It has many lands. You see, many names are there.
So for the first one is concerned, is the original Patadar, Sandranath Bora. Then, from him, Jodunath. From Jodunath, Debo Mikir has purchased, and from Debo Mikir, I have purchased.
Debomika's name is there.
Yes,
Your name?
my name is also there, Sri Devi Surana.
TDP Surana's name is there.
Yes, yes.
Then it has been mentioned as Sarkar.
Yes, after resettlement operation 2009, it has been shown as Ceiling Sarkari.
How did it happen? And during the resettlement, it has happened. Otherwise, there is no other reason. So here he says, this person says, let's see this particular there cannot be a ceiling. He has only 2 bighas of land. So 2 bighas, how can there be a ceiling in that? Ceiling surplus. I think this is a case of correction. Do you have any other land?
No, on that. That
Then how can there be a case of ceiling surplus? Did Debomiki have? When did he purchase?
73,
73.
Yes, madam.
So 71 must have been the period. When was the ceiling proceedings initiated? I think this was done in 1971.
Yes. Already,
This was only brought in the resettlement proceedings.
yes.
An officer must have done it.
My mutation was done in 75, 76.
So therefore, I'm saying your mutation was done then. But the question is, if it was a part of earlier fixation of land proceedings, they come under the fixation of land proceedings. Is it or under the urban the land ceiling act?
Urban rental.
1971.
And when the respondent.
Four.
Next, eight is the letter of metal.
So your land now, as per the resettlement operation, is which dark?
They have formed two ducts, my lord. 2874,
2874
2874, my lord, and
and 2890.
yes, 2890.
This is the total.
Total land.
So they say that these 2874 and 2890 comes from dark number 1495. I think this must have been 1495 is old one,
The old one, my lord.
absolute old.
Yes.
Then comes 1236.
Yes, after that 1236.
So see your seal deed.
1495, yes.
Old one is 987.
1495.
1495 is where do I find it?
In my petition, my lord, is my lord, page 60, my lord.
See. 1495 seems to be the middle one. Isn't it? Okay. Slash 1495.
Yes.
It means subsequent to this. And then 1495 becomes 1890, isn't it? But you are saying 2874. What is this 2878?
My lord,
890. So what is 2874? How much is the total land here? 190 R. How much is that amount to?
yes. My lord, what happened was 1495. Initially 1236, my lord, then 1495. From 1495, my lord, these two ducts were formed, 2780 and 2874.
28,
28,
2890.
2780, my lord.
I know 2780. You get 2780. 2790 and 2890. And kindly come to page 60.
Yes, sir. Yes, sir.
Okay.
2790.
Okay. Now, what is this? Then how do you explain this one? Page 94. That. But the land measuring what and what is the total land here?
My lord,
9.93. How much does it correspond to?
yes, ma'am. 9.94. 9.90.
So there's a Miyadi Patta on this 298.
Yes, that
So-
is my patta, my lord.
Have you got the Patta?
Patta was not issued, my lord. It was
But do you
supposed to
have
be
a
issued in
patta?
2009.
Huh?
It was supposed to be issued in 2009.
Then?
We're not issued. Because the issued made Sarkari document.
Then how did you get this copy?
Well,
No, this copy is different from what is the circle officer is saying in his affidavit.
So this is a draft sheet, my lord. Copy of the draft sheet are just here shown.
Understood, but this seems to be different because here in his affidavit he says about 2874.
Yes. This 2874 is another document.
I don't understand the thing is page 60 says
Yes.
1236 1495 and there are two DAGs
Yes.
2790 and 2890.
Yes.
But the affidavit filed by the circle officer says 12395 and two DAGs 2874 and 2890.
That's what.
You get the point?
Yes. I got the point.
Have you thought about it?
Yes.
What is your answer?
So that's what was how he has got that doc. I don't know.
You have to make the submission for this court to make the submission to you.
No. So 27, my dog is 2790, madam.
Better clear your head. This is matter. Help it unless you come up with proper things. How do you say it? You have to say to me that this affidavit is wrong because of this. How do you explain this? That the document at page 60 is different from the document which is at other one, 2874. The affidavit. Or is it a different plot of land which has happened? And you cannot merely say that this is the ceiling surplus. Ceiling surplus has to be prior to something because obviously the ceiling surplus could have been at the initiation of somebody else. Somebody else land. So it has to, somebody had more than 50 bighas of land. No. As per the 71 ceiling plan, what is it? How much it was? Fixation of ceiling act is outside. Urban ceiling act, how much it is? 6 bighas. Huh? As per the urban ceiling act, how much it was? 1971. This matter. When do you want? Prepare yourself. You can't come up like this. But you see that this act was repeated. So therefore, all this land therefore vests. When?
Next Friday. Friday.
Not Friday. I'm not. Friday already minimum. And then next week onwards, I'm not there.
What
Let
is
you trouble somebody more.
what is the one?
Huh?
What is
Absolutely no. I'm trying to push beyond and you have to coming before. Okay, leave
January-
this matter on
January.
4th of December. Bring it to the another one, he may understand. In the meantime, the state, hello, let us have it on 11th of December. In the meantime, the state respondents are directed to bring on record their stand as regards the ceiling surplus case number 225 and as to under what provision the said proceedings were initiated. Because it could not have been initiated under the 56. At that point of time, it was there. This land will be where? Where is this land? Beltola. So it may be within here, the city. So has to be.
May I plead? Malab, unfortunately, I have lost a brief of this case.
Huh?
I have lost a file, my lord. So I will manage today itself to recollect the file, my lord. Lordship may kindly fix it as per your lordship's convenience. Possible, my lord, the day after tomorrow.
Preparing? What is he asking for?
Mention of mandate.
Your name? Dilip De. Who is Narayan De? Narayan De is your father. Your father. Her house is in another town. Hello. The case, your case is the land actually belonged to Nokul Chandra De.
My lord,
That's your father.
my lord,
Nokul Chandra De had two heirs,
Hmm.
his wife and his son,
Son.
that is the petitioner.
Hmm.
And they were inserted, their names were duly inserted in the year 1990.
Well.
However, on the basis of some mistakes, Narayan De's name was inserted.
my lord,
So you filed an application for removing that name.
Well.
Circle officer, therefore, on the basis of whatever it is, forwarded to the authority,
Well.
stating that this needs to be corrected.
correct. After
The
conduct-
additional district commissioner directed this correction. But in the meantime, Narayan Day expired, and on the basis of inheritance, Dilip Day's name was inserted. That's the response number 8. Exactly. Because his name was there. So there was another mutation order.
my lord,
Now
that is-
you therefore have approached this court for compliance to the order passed by that person,
Exactly, my lord.
to the effect that that area should have been properly corrected.
No, no, my lord, that is an additional ground, my lord. But, my lord, the vital aspect is that, my lord, they, after conducting a hearing, as, that they have, my lord, after verification of all the relevant documents, they found that the name of the private respondent has been wrongfully mutated. Thereafter, it has been directed to, my lord, corrector land records. They have exchanged some letter in between them. But thereafter, no any correction has been made, my lord. That is the, my lord, only, my lord, that, my lord, the for
So
correction,
not to
because
give
they,
effect. Now,
my lord, that's why.
as per the Lot Mondal's verification report, Dilip Day, that is the respondent, had constructed a house
My lord, they are saying that they are,
at PP number 24, dark number 58, whereas your land is PP number 25, dark number 74.
my lord, that is some, that, some, the town committee has, my lord, has given some difference. My lord, states documents are not available with me. So, but another aspect I would like to, my lord, draw your lordship's kind attention. So far as I remember, in the affidavit filed by the government, they are saying that the name of the private respondent has been inserted by way of actions between the Asubalate, my mother, and this, my lord, that the private respondent. But so far, even we have, my lord, applied for the certified copy of this, that, my lord, deed of exchange. Well, there must be some documents must be existing. My lord, there's, if any exchanges, my lord, has taken place earlier, but nothing is there. They are
And you have
giving
not
the-
filed your affidavit.
So they are not, my lord, annexing any record. Only they are, only, my lord, averments are there. Government is only, my lord, making the averments that there is by way of exchange, my lord, 2 kathas of land. But they are not denying that, my lord, that the land record has been, my lord, corrected. They are not, my lord, assuring. They are, my lord, only making the averments. They are not, my lord, annexing any document to substantiate their claim that there is some exchange or anything like this. It is admittedly, my lord, that the name of the private respondent has been, my lord, mutated. But there's
On what basis did this exchange happen?
nothing is there, my lord,
Madam?
document.
How did the exchange happen? So at that point of time, the Registration Act did not apply in the asking. Transfer of Property Act did not apply. How can there be an exchange without a registered document? How? There cannot be an exchange. Exchange means there is a confirmation of a title. One person to the other. Whatever may be, there has to be those documents. Where is it? Haven't you placed? Huh? Why? First of all, without a registered document, there cannot be a valid exchange in either. So there has to be a registered document. There cannot, by way of a relinquishment, title cannot confer upon you unless you have a title earlier. If you don't have a title, nothing. From the materials on the, well as the affidavit filed by respondent number 5, there 5 and respondent number 10, there are certain references made as regards some exchange of land. However, there is no documents in support thereof placed before this court. Otherwise, the learned counsel appearing on behalf of the respondent number 10 submits that you place those documents on the basis of which the petitioner, the respondent number 10, claims that there was a valid exchange. List this matter again on 8th of January 2025. In the meantime, such affidavit be filed on or before January 2025. It is made clear that if no such affidavit is filed, this court shall presume that there is no. In the meantime, you prepare. Have the
I
file.
apologize for the inconvenience, my lord. Okay, it's your file.
Okay, we have it on 22nd. We stay with the file. 22nd of January.
Item 10,
May I please, Your Lordship? And this is regarding the non-payment of contractual bill, my lord. Earlier, Your Lordship disposed of similar matter, my lord.
Finish the disposal for you.
There are two details there. There are two details there, my lord.
There are two, the changes will be there, na? What are the changes?
Name of scheme and amount, my lord.
Huh?
In my petition, there are two, my lord.
In his petition para. Suppose.
Obliged.
12,
None appears on behalf of the petitioner on earlier occasion also has appeared on behalf. It that appears from the affidavit by the respondent number 4 that most of the payments have already been made to the petition, except an amount of rupees 76 lakhs 1,849. Appear that from the materials on record that the petitioner must have in the meantime received the amount for which the not interested in the matter. Accordingly, the petition stands closed. Non-prosecution.
13,
Regarding ex gratia under, my lord, motor accident, my lord.
Huh?
Motor accident, my lord. Ex gratia, my lord. This matter may be taken up after 4 weeks, my lord.
What is that?
Ex gratia matter, my lord. Ex gratia,
Ex gratia for what? 1511?
my lord.
Where is the FIR? Car is there.
FIR is case 18, my lord.
Dismiss. এইটো সেই judgment লগাকে dismiss করো।
After 4 weeks, appeal is pending, that is.
Oh, miss.
14,
Following Justice Surana's order, if payment cannot be given, put the order also.
But-
Exclusive. Yes, what is this?
During the pendency of the case, my lord, the petitioner has died, my lord. So I need to file a substitute petition, my lord. They allow.
Yes, what has happened in the meantime? Award part?
My instructions are that. But like this. Here the LA case is 9 of 2001. Our case of LA case of 9 of 1993. When the matter has been finally demanded on the judgment passed by the Supreme Court. Come up with 2 months, so they were not made a party. And lordship was pleased to dismiss the round of delay.
So this is different.
My instructions are that we do not know what is LA case number 9 of 2001. They will have to respond, my lord. But still.
Yes, state. What is this LA case? Has the award been passed in LA case number 9/2001? Just find out. The emboldenment, the learned counsel appearing on behalf of the state, whereas the district administration shall obtain instruction as to whether there is any award passed in LA case number 9/2001 and further as to whether the petitioner or his legal representatives are beneficiaries of the said award. List the matter again on 8th of January 2025.
In the meantime, may I file substitution petition? Obviously.
In the meantime, you do whatever you do.
15,
What is this?
Lordship. May you please produce annexed to Lordship, where the names of the petitioners are given, Lordship. They are recommended as the member of.
I'd like to recommend the following social workers
Yes.
under 32 LAC for constitution of different LAC level. Name is not there. Your name is not there.
My name is here, but without informing us, they have made another party which is in annexed court, Lordship, by dissolving the previous member. The new members are included.
So, what is your right?
Lordship.
What is your
But
stand? Who has done all these things?
responding on this.
That minister is no longer there. Yeah. Madam, you see, you have a big problem. There's no welfare of plain tribe and backward classes department. There's no welfare of scheduled caste Assam department. Deputy Commissioner, Bongaigaon, Subdivisional, Bongaigaon, all these things you have me. Okay? And in the meantime, what has happened? Your names have been inside, your names have been removed.
Yes, Lordship.
What is your right to remain in the land? What is your right? Show me your right that you have a right. Are these
As per
people outside the local area?
Annexure 3, Lordship, here is the notification.
Hmm.
Where
This is a recommendation. Whether the recommendation has been accepted or not.
so there is a notification, Lordship.
Madam, there is a notification wherein your names have been there. But the fact that there is a subsequently a recommendation being given, has the recommendation been acted upon? I'm asking you that. This is not a notification. So for coming up with a notification, there needs to be a recommendation, no doubt. But upon the recommendation, has there been a notification? And if not, what case do you have today? Isn't your reputation premature? Oh, heard Miss So-and-so, the learned counsel appearing on behalf of the so-and-so appears on government advocate, appears on behalf of administration. And you are appearing for whom? So-and-so appears for deputy. Petitioner herein have assailed the recommendation so made by the Minister of State Irrigation Independent Education Department on 22/1/2020, whereby various persons, the private respondents were recommended under 32 Bongaigaon LLC for constitution of different LAC level selection committee. This court put a specific query upon the learned counsel appearing on behalf of the petitioner as to whether pursuant to the said recommendation, there has been any change to the notification dated 17/7/2019. The learned counsel, however, did not have any instructions in that regard. Be that as it may, it is the opinion of this court that merely on the basis of a recommendation, there has to be a notification to give any right to the petition, a cause of action to the petitioner to approach this court. As there was only merely a recommendation, but there is no notification followed thereupon, the instant petition is premature, for which the same stands dismissed.
15,
I'm free. Or part watching. Section, the central petition law. Asking for the
To place instructions before this court as to what happened to the application so filed by the petitioner seeking allotment of land and to what decision has been taken. Mr. H. Sharma, the learned counsel, government advocate appearing on behalf of the respondent state submits that some more time is required for obtaining the instructions in terms of in 2024. Accordingly, list this matter on 8th of January 2024 to 25. In the meantime, the affidavit so directed, the instructions so sought for, order dated 3/10/2020, and we shall be placed before this court without fail.
18,
Wait, please, so much.
has been submitted that the counsel who is representing the APDCL is of his personal engagement would not appear to be this matter again on 2nd of January 2025.
Can it be in December, Malad, anytime in December, Malad? Kindly, Malad. There's a small issue involved, Malad.
On 16th of on 16th of December.
Obliged. Obliged.
19,
Made piece of art. But in this matter, the respondent authorities have to respond as to whether for the period the establishment was closed, the establishment charge is required to be paid by us or not. When it brings the demand, we submitted the reply.
Establishment charge you have to pay. There's
Whether
no
or not-
way out.
If that is the only thing, it is pending with them also, that for the inoperative period, it's not denied fact, it's an admitted fact by them that April 20 to October 22.
Establishment charge is in terms with that order of 9/6/2016, isn't it? Whereby it says that at the time when there is a transition from the old act to the new act, there is a requirement of the change of the bonded warehouse to wholesale warehouse, which will require the bonded warehouse, the wholesale warehouse to pay the amount of tax and excise duty.
Under the
So
excise.
therefore, they are required to make the payment. So this is the amount which you have to pay.
This, when they are under consideration of it, rule 461, if I may invite my lord's attention. to this, my lord.
What does it say?
It says the state government or the excise commissioner shall appoint such officer an establishment as it thinks fit to the charge of the bonded warehouse. The licensee of the bonded warehouse shall pay to the state government at the end of each calendar month such establishment charges as may be determined from time to time by the excise commission. The cost of the establishment shall include pay as well as leave salaries, pension contribution, etc. So what we are on is that
Has it been renewed? They renewed it also.
that is there. The renewal sanction was also there, we have annexed. The renewal sanction, my lord, is also there, we have annexed. The renewed it also.
Then
Then that determination by them, and I'm told, my lord, in April 24, they have submitted a representation which have been received by them on this check also. I do not readily have a copy of the hard copy of that, my lord. But they may respond to that. The renewal is
but
done.
there is no stay to the.
There is no stay.
Then,
There is no stay, there is a renewal as well. There has been a renewal of
my goodness.
renewal as well.
Excise, who is appearing for excise? You are paying for excise. Why you are not doing something? Cancel the license.
There is a renewal of it.
There is one judgment passed by me, which is, it's categorically say that they have to pay the establishment charges, whether they operate or not, that is immaterial. Then, then,
Of course, as per law, if the establishment charge.
not
for the period-
establishment, fee, that you have to pay, there is no way out. So we dismiss the petition and stop the renewal, cancel the license.
License cancellation was never an issue.
You have asked for that, your apprehension was that because of non-payment of the establishment charges, you should not
According
renew.
to we have,
They would not renew.
we have,
Now they have renewed it.
we have pleaded.
So,
We have taken a plea.
so your apprehension has become, you have renewed, so withdraw. Better. The only question was that. Your
Would it
apprehension
be listed
was
tomorrow, my lord?
not
Still matter
tomorrow,
of it.
now. Your
At two.
your apprehension was simple.
I get the
That
point.
look here, that there is a pending establishment charge, and because of this establishment charge, they would not renew. Now they have renewed it because of getting that interim order,
Could I come back?
a
at
kind
2?
judge. But now it has again fallen back to another Unkind. So because of that, this has happened.
Lordship, I can give the instruction.
With your instructions. With 2 o'clock.
21,
What is this? What is your instructions? Huh? Fantastic. Is he entitled? How much he is entitled from you? From you. And otherwise, have you got from Jal Shakti? There will be a bifurcation, isn't it? You seem to be not aware. Mr. C. Sharma, the learned counsel appearing on behalf of the Water Resource Department, admits that he is unaware of the facts and as such seeks for an accommodation. In addition to that, none has appeared on behalf of the Union of India. Yes, Mr. Gogoi, you can appear. Huh? Okay. In addition, to that, none has appeared on behalf of the Union of India on call. This matter again on 22nd of January 2025. In the meantime, both the state, the Water Resource Department of the Government of Assam, as well as the Ministry of Jal Shakti shall bring on record their stand by filing their appeal.
22,
May I pray if the matter will be taken up at 2 p.m. Lordship?
Why? I have already too many matters with two.
One thing is that we have filed an affidavit in reply. It is to be brought on record. This is regarding a land acquisition matter and compensation issue. And I'm led by Mr. M.K. Chaudhary.
Oh, this matter.
Yes, Your Lordship. Once you can take it up at 2, I have filed an affidavit reply. That will be also on record.
This matter pertains to what?
Regarding that issue of award, Lordship, whether the award was actually passed or not.
Oh, I
Last
asked
week,
them to
also
bring the
looking at
records.
Found there
Where
was
is
an award.
Mr. H. Sharma? He was the main person. He said that the records are voluminous. Isn't that?
Yes.
Where is he? Ask him to.
I'm
It
also
is
led
the
by Mr.
question
M.K.
as to whether if the award was not passed earlier, then the question would be payment as per the new act.
Yes, Lord. In the earlier round of litigation, what was the issue was the matter was sent back to ascertain whether an award was there or not on record. So the records were there before lawsuit. In fact, last occasion had found an award. However, whether it was filed or not was the issue, because an award has to be also filed. So that was the issue which we were supposed to look into in the records.
But was there approval?
To our understanding, there was an approval. Because the mode that has been followed in Oil India Limited, in that particular mode, the approval was there. And in fact, the demand was also made to us by the deputy commissioner asking that this is the amount that you are supposed to pay. So if we had paid the money,
That demand is at the stage of Section 6 itself. You must have entered into an agreement as per 40. Yes, award went past. Where? You filed your affidavit when? 29/8, there is an affidavit filed by respondent number 5. Number 4 is filed. Oh, 29, yes. Oh, okay, fantastic. As total is 49 and the award and the approval.
That's one number 4.
But did you file an appeal, Mr. Chaudhary, against the order dated 2/3/2023, passed in WPC number 7797/2017? Did you file an appeal?
No, against that, my lord, we have not preferred any appeal.
So wasn't that the findings made that there is no award passed
Yes, my lord.
as attained finality?
My lord,
And therefore the non-application of 24(2). Because 24(2), prior to Indore Development Authority say that if an award is being passed and possession or money was not deposited, then it lapses. The judgment which has been passed by an Indoor Development Authority says possession or the compensation is paid, or so that the end was made, or.
Yes.
So therefore, now either of it has happened. So the question therefore was that if there was an award, so there is a finality right there that there was no award, and as such 24(2) could not have been applicable. This was held in the year 2023. Without the challenge, wouldn't this court be bound with that observation that there is no award?
My lord, my submission will be, my lord, your worship has to understand a little background, my lord, the practice that has been followed. So far as, my lord, the Oil India is concerned, and which is the case here also, my lord. Initially, we apply for the, my lord, right of way. Right of way into the land, which is proposed to be, which is required for us. My lord, this purpose is for, my lord, the drilling of exploration of oil. Now, that was applied in 2000. And in 2000, my lord, the authorities, the deputy commissioner has allowed us the, my lord, the right of way. And after the right of way, what the normal procedure is that, my lord, there is a rate fixed, my lord. They call it, my lord, zonal valuation. On that basis, my lord, the parties bid and pay the compensation. Now, here in this case, the company from which we to acquire the land, they had not agreed to that, my lord, zonal, my lord, the zonal, the valuation of the land and the, my lord, GRA. Then what happened, my lord? A bipartite procedure was normally followed. It was, my lord, that is, my lord, under Rule 190 of the Assam Land and Rules under the Assam Land and Regulation, my lord. Rule 190. So, my lord, when, my lord, that right of way was given to us by the deputy commissioner to enter into the land and, my lord, develop the road and whatever we require, then, my lord, they filed writ petitions before this honorable court, challenging the virus of the Rule 189 and 190. So that, my lord, the challenge was rejected by this honorable court, and the honorable court directed that the process of acquisition under the, my lord, the old act, that has to be initiated, and it has to be completed within a period of 6 months. That order still stands, my lord. And a portion to that, my lord, notification under Section 4 and Section 6, that was, my lord, those were issued, and there was a typewriter agreement between the, my lord, the Oil India, the deputy commissioner, and the, my lord, the company from which the land is to be acquired. And, my lord, there the rate was fixed. The valuation of the land and the GRA, that was fixed. Of course, my lord, it was said that if subsequently zonal valuation is increased, and it may be increased, and pursuant to that, my lord, the parties have, my lord, parties are bound by that. That happened, my lord. After that Rule 199 notification, my lord, right of entry was granted, and possession of the land was handed over on 27/11/2000. So, my lord, yes, ma'am.
It is much prior to.
Much prior to it, my lord.
Prior to the initiation of LA 191 and
Yes, my lord, LA Section 6 and Section 4 notification, I'll give the dates, my lord. These notifications were issued on 8/8/2011 and 17/9/2011.
So you were handed over the possession prior to that?
My lord, the possession was handed over on, my lord, 27/11/2000, 2000, my lord. But
Then-
notification came in 2011. Okay. So, my lord, possession
So
was
this
already-
possession was handed over. But it's an illegal possession.
my lord.
There cannot be a possession handed over. The authority had no business to hand over the possession.
My lord, that was on the basis of that, my lord, that the my lord, the invocation of the Rule 190 and the Albano tripartite agreement.
That was okay. Tripartite agreement is a different aspect. But the fact that question of handing over the possession has to be done by the state. By acquiring the right to hand over,
My lord, that
where is
was,
the right of the state to hand over?
my lord, under Rule 190, 190 of the my lord rules under the Assam Land Legal.
What does it say?
Rule 190 my lord.
These are mining leases.
My lord, but
There's
yes,
nothing to do with mining lease.
my lord, this exploration of oil, perhaps my lord, that has also been.
Where the
put in-
surface of any land covered by any mining lease is in the occupation of any person other than the lessee. Are you going to go for mining there?
My lord, exploration of oil is some kind of, my lord, mining of the oil from the, my lord.
Understood, but where you going? Are you going for mining in that area? Are you mining in that area? Now, are you doing the oil drilling in that area? You're drilling oil. Okay. So then why the 1894 Act was applied at all? And not the other one?
No, my lord, the earlier act was, my lord, involved because of the fact that, my lord, the challenges were made of the, my lord, the rule 192, my lord, that permission was granted. Those were challenged by this honorable court, before this honorable court by the party. And this honorable court said that you initiate a proceeding under the 1894 Act.
That has attained finality.
That has attained finality, but my lord, it also says that you complete it within 6 months.
That is a different aspect.
And they have done
But the
it, my lord.
fact that you can't continue on the basis of 189 or 190 is also there. Therefore, there was a direction for land acquisition under 1894. So once there is a direction for 1890 for acquisition, which has retained finality, there is an acquisition which has to be carried out. Now, once the acquisition is carried out, there is notifications under section 4 was issued, section 6 was issued, declaration under section 6 was issued, directing you to, whereby the land was specifically acquired for the purpose of your land. With the section 6 declaration, the government therefore has come to a final opinion that this land is required to be acquired for your purpose.
Yes.
This is a conclusive piece of evidence. Now, within 1 year, 2 years, there is a requirement of passing of the award. In the meantime, you continued with the possession. So the possession is already there. No award is being passed thereafter. There is some challenge being made by you by filing a writ petition. They had also challenged another by filing a writ petition in 2017, isn't it? So all these writ petitions ended out there, wherein it was said that these writ petitions ended with a judgment passed from 34 when these two writ petitions were disposed of, no? Huh? Page? Ah. This is a writ petition. So many writ petitions together. 5/4/2011. So this judgment says that you have to acquire. Acquisition.
In fact, my lord, if your lordship permits me, I'd like to-
Agriculture with the immediate steps if not taken order to initiate process on the acquisition for compensation thereafter vis-a-vis the lands of the acquisition involved in demand. Meanwhile, the area has not yet submitted its proposal to the done. To ensure that the process of acquisition of land is speeded up, avoiding undue delay, the party needless proceedings shall be completed within 6 months. Now, within 6 months, it is to be completed. Then what happened? LA case initiated. Where is the order passed in 2000, disposing of those two writ petitions?
My lord, May
Huh?
I implore your worship to read paragraph 6 of the judgment, my lord. Paragraph 6 of the judgment, my lord.
Of
This judgment, my lord. Please,
the division bench.
my lord, the judgment, yes, my lord.
It's okay. No, let us see where is the judgment.
My lord, before that, may I implore your worship to kindly read, my lord, some observations in this judgment, in this division bench judgment.
It's okay. Let us see the 2023 judgment. One. This Nandlal and Saul 587 of the 2017. What is this? 189 under the Emmanuel challenge has been made to the invited to revisit the proposal letter dated page. That is not that. No, where is the judgment of 2023?
Class at 141, my lord.
Okay. Ah. Oh, yeah, if you come to paragraph 14 at page 151. Therefore, this aspect has not attained finality. Accordingly, we direct the Deputy Commissioner to look into the records and arrive at its own fair conclusion. In the event an award under Section 11 exists, the implication thereof be followed so that the landowner receives the appropriate for the land that had been acquired. And if on the other hand, the Deputy Commissioner arrives at its conclusion that no award has been made under Section 11, the provisions of so and so be made applicable and the process be brought to its logical conclusion. So therefore, it is not final. See, what they have mentioned in the affidavit is different. 2/3/2023. Kindly see their affidavit which was filed on 30/29. Kindly see paragraph 14, page 203. That by order dated this court dispose of holding that no award is available on record. This is wrong. No, that is not the finding. Therefore, what is given in paragraph 14 of the judgment?
151.
No, 151. 151 does not say so.
Accordingly, we direct the Deputy Commissioner Tinsukia to look into the records and arrive at its own fair conclusion. In the event an award under Section 11 of the Act of 1894 exists, the implication thereof be followed so that the landowner receive the appropriate compensation for the land that has been acquired. And if on the other hand, the Deputy Commissioner Tinsukia arrives at his conclusion that no award has been made under.
So it is only when there is no award. So there is no finality arrived at in the 2023 judgment that there is an award or not. So therefore, we are to look into the file where I'm coming back at 2, where get the file.
If that is file number TRQ 19505, take the record, my lord. Your worship will find the approval at page 150 and 152.
Where is your agreement with the? You must be having an agreement. Pursuant to, if it is done under 1894 Act, if you are doing for a company, you have to have an agreement, and without an agreement, the entire it is not permissible. would be non-compliance to section 40 onwards. Where is your agreement?
One of the tripartite agreement we have annexed at 389.
No. Tripartite, no. See, kindly see section 40 of the 1894 Act.
Section 14, my lord, 1/4.
Section 40
14.
for you.
Previous inquiry.
Huh?
Previous inquiry.
I think 39, then I see.
Previous consent, appropriate government and execution of agreement necessary. The provisions of section 6 to 16, both inclusive, and section 18 to 37, both inclusive, shall not be put in force in order to acquire land for any company under this part unless with the previous consent of the appropriate government, nor unless the company shall have executed the agreement herein of the
Where is the agreement?
That agreement, your lordship, my lord, that is what, my lord, I was saying that tripartite agreement. That at
The agreement has to be with the government,
my lord,
not with
deputy
anybody
commissioner-
else.
Deputy commissioner, my lord.
Huh?
Deputy commissioner. Deputy commissioner is a party.
No. There has to be an agreement. Where is that agreement?
Page 89,
Page
89.
No, this is not an agreement. This can't be an agreement. This is my notes.
My lord, if you actually see, my lord, the operative part, in view of the above, page 90, in view of the above, the following.
There has to be a
decision-
written agreement. Isn't it the requirement of having a written agreement? Without a written agreement, you cannot. I can't know why.
My lord, there it has been agreed, my lord,
Without an agreement, there cannot be an acquisition. You cannot give a declaration under section 6 without an agreement.
my lord, in my humble submission, my lord, the conclusion that has been arrived at in presence of three parties that has been recorded, my lord.
It
and
has
the-
to be a written agreement. Where is the agreement? There's no sign. Nothing is there. Cannot happen like this. You may use this for the purpose of 12.2, 11.2. You may use this for the purpose of 11.2 of that particular Act 1894. But without that agreement, how can it be possible?
The decision has been taken, my lord, that is what.
Decision won't help it.
Presence of all the three parties, my lord.
Execution of an agreement is necessary. The provisions of 6 to 16 and so shall not be put into force in order to acquire land for any company under this part unless with the previous consent of the parent, nor unless the company have executed the agreement hereinafter mentioned. Now, what is the hereinafter mentioned? There is a categorical agreement how it is to be done. Such consent shall not be given unless the appropriate is satisfied either on the report of the collector under 5A or by an inquiry held so and so that the purpose of acquisition of the acquisition needs for construction of a company which is engaged so and so. Agreement 41. If the appropriate is satisfied after considering the report, if any, the collector under section 5A or on the report of the imam, the proposed acquisition of so and so, it shall require the company to enter into an agreement with the appropriate government, providing to the satisfaction of the appropriate government for the following: the payment of so and so. Without this, how there can be an acquisition under 1894?
That matter we have to check in the record whether the agreement is there in the record, my lord.
No agreement. So it goes for a fresh acquisition now as per law.
My lord, my submission before your lordship is that, my lord, the question was, my lord, whether there was an award under the section 11.
That is one thing. But without an agreement, there cannot be an award. You cannot put in, you see, the most pertinent aspect is section 6. Without the section 6 declaration, although section 4 initiates the proceedings, but section 6 is the proceeding by which the government forms an opinion to the effect that this land is required for the purpose of the company. So under such circumstances, this section 6 does not come into play without that agreement. So entire thing has to go.
My lord,
Unless you say, because you are challenging the award. Are you challenging the award now? If you are challenging the award now, that means there are two options. If an award is there, possession has been already given. The land vests upon the state, and the state may have given it to you. This is one. By which it is becomes irreversible. It does not go back. But if you don't challenge the award, or if you say that the award is bad, then the vesting does not happen. Just for example, the judgment of the Supreme Court in Indore Development Authority categorically say, while it was forming its opinion under section 24(2), says that once the land, once the award is being passed and the possession has been taken either under 17(1) previously or after possession is being taken under section 16, the land vests upon the state and it becomes an irreversible thing. So 48 also would not come into play. The court can, the government can resile back from an acquisition proceedings, but once possession is taken, you cannot. So therefore, if there is an award, here in view of section 24(1)(a), it is only to the effect that when an award is being passed and after the passing of this particular thing, the Act of 2013, only the acquisition, what you call the compensation is to be adjudicated in terms with the new Act, nothing more than that. But otherwise, all other provisions still controls the field. Therefore, this Act of 1894, which was amended by the 84 Amendment, whereby companies were brought in, there is a requirement of having an agreement. Without an agreement, nothing happens.
my lord,
Either you challenge.
May we look into this fact from another angle, my lord. There was, my lord, approval of the estimate. There is no dispute to that, my lord. And pursuant to that, we are directed to make the payment. And my lord, had we made the payment at that point of time, my lord, the thing should have been closed there itself, my lord.
You were asking for reducing the amount. There you lost the bus again. You should have paid then.
My lord, the question is regarding the existence of the, my lord, award. Had there been, my lord, no award, we
But
could not have.
whether there is at all an award, can you say this an award without an agreement? Tell me. Therefore, the reason arises when you are taking on behalf of a company, when you enter into, there will be, what are the contents as per 41 it says, categorically says a very interesting aspect. That is why I asked for the agreement. The payment of the appropriate government to the of the cost of the acquisition. So this is nowhere there. Therefore, the problem is happening. They are asking all these things. They have been asking you, demanding you this amount.
My lord, once the, my lord, amount was demanded from us, my lord, we were directed to deposit, my lord. That presumes that, my lord, there is an award. Otherwise, my lord, we could not have asked for making a payment. So if that is there, my lord, and if you are asked to make the payment, my lord, that is the end of the matter so far as the acquisition proceeding is concerned, my lord. That's why, my lord, we say that there was an award and, my lord, the approval in form 5, my lord, the format was filled up and that was sent to the government and we were directed to make the payment. So, my lord, if there were some lapses on the part of the authorities in following the procedure laid down by law, my lord,
This is not a lapse on the part of the authority. They cannot be. You cannot bring in section 6 without an agreement.
Precondition.
That is why the problem is being faced. In all cases, there has to be an agreement.
because, my lord, my lord, as your lordship has, it has fallen from your lordship, my lord, that is a prerequisite for compliance of section 6.
Otherwise, 6 cannot come into play. Therefore, you see, 40, it says, 39. The provisions of 6 to 16, both inclusive, and 18 to 37, both inclusive, shall be not put into force in order to acquire land for a company under this part, unless with the previous consent of the appropriate government, which is there, nor unless the company have executed the agreement hereinafter mentioned. Hereinafter mentioned is in 1141.
So, my lord, the presumption that we will, my lord,
So
proceeding.
there is no acquisition.
That, my lord, is 89 is an agreement, my lord, that is not an agreement in strict terms of the section.
There cannot be an agreement to that effect. The agreement has to be written it down.
But would like to check the records, my lord, if that agreement is there, but in any case, my lord, whether, my lord, fault can be attributed to us, there was an award. We are directed to make the payment.
Then you see 42. Every such agreement shall, as soon as may be, after its execution, be published in the official gazette and shall thereupon, so far as regards the terms on which the public shall be entitled to use the work, have the same effect as if it has formed the part of this act. So, I think
I understand that, my lord, but at the same time, your lordship will also consider.
either you ask this thing to be reach a quietus, thinking whatever has happened, it happened, it's okay. The compensation has to be regarded as on the date of that thing. Which is there. They have taken it, they have only applied the solatium and 100% solatium, and twice, if it is the case of a rural area, they have used 26(2). And that's it. Or entire thing goes. What do you say, madam?
My lord, there is no challenge to the award, my lord. There is no challenge to the award. Only.
You are only challenging it.
My lord, we are only, my lord, agree by the.
So
party.
therefore, the question of directing them, asking for you to make the payment does not arise.
My lord, we have challenged the valuation part only, my lord.
Understood, but then also there is no award filed. Whether the award, yes, there are various correspondence to the effect that yes, this is the approval we have received. We have been asking, let us demand first, let them make the payment, then they are waiting for the payment. In fact, if you see, the payment is a condition precedent for the purpose of acquisition. In fact, however, if you see the judgment of Ultratech, it may give you some insight to that effect, wherein it has been said that the payment was directed to be made by Ultratech. Ultratech did not make the payment, and as such, the state was there. The Supreme Court said that it was the bounden duty of the state, being a welfare state, to make the payment and then to realize it from you, from that authority as what you call, for recovery of the areas of land revenue. So that is there. But without that, how does it happen? And if this thing goes, if you can't apply 6, what remains? What do you say, madam? Are you going to file a writ petition?
For compensation again?
No.
Challenging the
For
award.
setting aside the entire thing and going for an agreement. Without an agreement, how can they happen? And thereby now they will have to.
24-1. It's taken possession.
The entire thing falls.
That doesn't happen. Possession is happening. That is, I mean.
How?
Lordship, at the end of it, I am deprived, 2000 onwards, they've had possession. If you lapse, it's very onerous on the person whose right has been deprived, which is why 20.1A says, doesn't matter, there's no award, you just get compensation. And our submission is there is no award. Agreement and everything follows, therefore. Without an agreement, there can't be award, and that's 24.1A and indoor. Too onerous on me, be deprived of my right, property, from 2000 onwards, and then again we need to go through the whole process of compensation. Therefore, 21A cuts it short and says possession is gone, with section 4 is started, new act. And Lordship, may I take you through one order of this honorable court, which
No, no, no. What I'm saying, Section 4, as per a recent judgment of the Supreme Court, says about the initiation.
yes, Lord.
So the initiation has happened.
Yes,
So
they
20
also issued a section 6 for whatever.
no, no, no. Therefore, you see, without an agreement, you cannot go for Section 6.
That's why I said for whatever it's worth. Yes.
So the value of the land has to be taken as on the date on which the market value was, as on that Section 4. Section 4.
Section 21, 24. Otherwise, the Lordship, look at the situation. Somebody takes my land in 2000. I get the value of 2000. It can't be, which is why this act protects me. And that is what Indore says. What is
No,
the-
no, 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 madam, kindly, you see, it is not like that. Kindly see, if you see that section itself, kindly come to 30. 30. 30.
the new act, Your Lordship.
Yes.
Cancellation, 100% now.
33. 30 bracket 3.
In addition to the market value of the land provided under section 26, the collector shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of publication of the notification of the social impact assessment study under subsection 2 of section 4 in respect of land till the date of award of the collector.
So every year there's an increase by 12%
Yes, Your
on the
Lord.
value.
Yes, Your Lord.
So they issued a notification in 2011. So that is the market value which is being calculated.
Yes, Your Lord.
So these 12 every year there will be an increase on that value by 12%. That is how you are protected.
Correct, Your Lord. Right.
But the question is, the government could not have arrived at a decision that the land was required for the company without an agreement,
Because section 6 was not possible.
without the section, because without the declaration, there is no decision. So there is no conclusive evidence. If you see the old acts, section 6.3, it says this only becomes the conclusive evidence for the purpose of that the land is required for public for the company.
And
So
that is
as
what
on
we-
date, without an agreement, there cannot be a section 6. So your value of the land, if we set aside the entire thing also, yes, they can go for an acquisition because initiation has already happened under 4.
Yes, Lordship, then what would be the meaning of 24? May I just take a Lordship to 24.1A of the new act? Notwithstanding anything contained in this act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894. So that's not to be section 4.8. Where no award under section 11 of the Land Acquisition Act has been made, and all provisions of this act relating to determination of compensation shall apply. So I'm relying on this to say.
Understood. Understood. But what do you say about section 6 of the old act?
They should have done it, but they have not.
No, no, section
I
6.
think that this
Section
protects us.
6 of the old act says that within 1 year, if you don't do it, the proceedings lapse.
My submission is, there is situation, money doesn't deal with the lab situation.
No, 24(1)(a) is okay. But then also, yes, due to various litigations, it may be going on all these things. But if you could not have initiated section 6 within 1 year, what happened?
Wrongly without an agreement. It's an honest
They could
thing.
not have. There's a bar, complete bar.
Lordship,
Therefore, these are the protections which are being provided. So unless you set aside 6, you see, kindly appreciate, there is a very important aspect. 6 says about lapse. But 11A, although there are 4 judgments of the 3 judges bench which say, there also from 6, 2 years, you have to
yes,
pass the award.
that's that. Yes.
But the Constitution bench in Indore Development Authority say that it would not, taking into account that the land by operation of section 16 vests.
Which is why 24.
No, the vest. But without 6. You see, 11A is on a different pedestal. So without 6, how can it vest? There cannot be a vesting of that right.
What happens to my right to property? It's valid.
You have it. You will get it. Don't worry, but you will get an enhanced amount now. I hope you have understood that my endeavor is that you are going to get more.
Yes, Your Lordship. Yes.
You want to reduce
Your
it.
Lordship, the thing is, the problem with initiation of air is taken from 2000 to 2024.
So there the
it's
problem,
another 24 years.
madam, the moment you challenge that aspect, the moment you challenge this aspect, this court has no other option. No agreement matters. Award or no award, everything goes now, but there is a duty imposed upon them for payment for going for acquisition.
Shade and complete.
So there is the order passed by the division bench. Huh?
Time frame.
Whatever time frame is,
The most crucial thing, Your Lordship, because they've been from 2017 onwards, there have been 3 months, 6 months, nothing's happened. And Lordship, our submission is there is, Your Lordship, now that whether there's an award or not award doesn't matter if there has been no agreement.
no agreement matter finished. So but they are bound to acquire.
And give me compensation. They've acquired already, Your Lordship.
No, how is the acquisition without that law?
Taken over.
They have taken over. For that, you ask for mean profits.
Lordship, one.
Yes, Mr. Shodhi.
My lord, I think I should be given some time to, my lord, find out whether there is an agreement, because, my lord.
No agreement.
No, my lord.
See the records, no agreement.
No, with the, my lord, with these, Indian, Oil India authorities, they may have, my lord, that I know of, because, my lord, we did not go into this aspect, section 6.
So that agreement has to be published in the official gazette.
True, my lord.
Then
My lord, whether that is there or not, my lord, that instruction I do not have.
Signed it. Our instruction that there is no agreement, so that cannot. There is no.
No, they cannot, they are not a party to the agreement. No,
they can't be a party to that agreement.
my lord,
The
agreement
agreement is between you and the appropriate government.
and the government. That, my lord, will try. to
Because
find
then the problem is solved.
out. Yes.
As regards the payment, the government does not have to insist because the government is bound. The government then can enforce. Without the agreement, how can the government tomorrow enforce upon you? That you are going to pay. That is why the requirement is categorically mentioned.
So let me have a clear instruction on this, my lord, whether they have a copy of the agreement or not. That is one thing. And my lord, there is, of course, that, my lord, Ultratech, I had not.
How much now you have to pay? 71 crores.
22 crores.
Huh?
22 crores.
Huh?
22 plus, my lord.
22 only. Pay that.
Crores.
It is what pay.
My lord, it was, 6 crores at the, my lord, initial 6 crores, and we were agreed by that, my lord.
The
We have-
problem which will arise is, as of now, you have to pay 15%.
My lord, 9 crores we have already paid, my lord.
Whatever may be, 15% interest. How much it will be? First of all, therefore, I think the respondent should challenge this.
That
The entire
not
thing
the-
has gone for a 6. You can't do it. There is no agreement, nothing remains. The entire acquisition proceeding 6 and all, everything is bad. But they have to acquire, hand over it to us.
Lordship doesn't think that 24(1)(A) protects us. 24(1)(A) is a situation like this, that you take possession. You start acquisition proceeding, you don't do anything about it. Which case, the new enactment says, don't worry, you get compensation.
Madam, kindly remember, 24(1)(A) only says that in the case that there is no award being passed where any proceedings have been initiated under the old act, then in that regard, the compensation has to be assessed in terms with the new act. So thereby, the provisions of section 26 to 30 read with the first schedule 1 has been statutorily incorporated into the 1894 Act.
It back.
So it dates back to that, and these have been there by 23 and 24. 23 is being taken away. But section 6 remains as it is. It is being saved. So section 6 remains as it is. Once it is remains as it is, and there is no declaration being made within 1 year, as per section 6(2), the entire thing goes. And the 6 could not have been made, irrespective of anything, in view of no agreement.
I will improve some time, my lord, to examine that as well, sometime. And my lord, there is another decision of the Honorable Supreme Court after indoor development authority, concerning matter from the state of Assam. Here also, my lord, that has been reiterated, and the facts in that case is somewhat similar to our case.
What does it say?
That is, my lord. My lord, 2021 3 SCC 388. Now, of course, my lord, because of the queries that have come fallen for your lordship, my lord, maybe this issue your lordship may not like to go into. Paragraph 13, 14, and 21. My lord.
Hello?
13, 14, and 21.
Can you come to paragraph 17 of the said judgment? Paragraph 19 of the judgment. If it was a government undertaking, it would have been different.
That's right.
How do you take care of without six,
Let me-
without a proper six, that there is an error?
Let me examine that.
Where the problem arises. And in view of the judgment in Indore Development Authority, wherein it says that there is a continuance requirement of payment of interest. It may not lapse, but it was in the other case. It is nothing to do with these proceedings or anything with the company. This point was never there. But this couldn't have been done. That was made. It was in 1984 when companies were brought within the fold. And when companies were brought into the fold, there was therefore the requirement of having an agreement.
Right.
So, madam, what to do?
One thing is clear, my lord, they will not be challenging the order.
If you don't challenge, which I have asked you have a problem with this judgment. No, this thing. Because you see, all this happened because there was a direction of the High Court.
Yes.
Yes, well, All happened with that judgment. Nothing was done. No. 2011 judge. They were happy with this amount, no?
They were happy.
Earlier, they had issued a notice under section 80 for making payment, and you have not. So many notices have been issued. Still notice issued. See, there is a difference in the language used in both the acts, both the notifications. In the two different LA cases. One pertains to the smaller area, where they say that is required for public purpose for drilling. There you may have some problem, may not have a problem. But as regard the 53 because the notifications is for oil India.
My lord, what happens, my lord, to what has been happening in all the land acquisition cases concerning the, my lord, oil India is that, my lord, that zonal valuation is fixed. That zonal valuation fixed between the, my lord, government and the oil India limited is, there has to be, my lord, some agreement. If that agreement is there, perhaps, my lord, that will also satisfy the other requirement. We would like to, my lord, look at that. So the procedure followed in other land acquisition and the, my lord, for oil India is a little different, my lord. We give the right of way, then thereafter, my lord, there is an agreement with the parties. On the basis, my lord, the parties pass.
Did you submit your written statement before the authorities?
So the authorities. I think there was no scope to file the written statement, right?
No, in 2017. Anyways,
Yes,
there
my
is no
lord,
agreement.
written statement that your lordship will find at page 114.
Hello. Yeah. Mr. M.K. Chaudhary, the learned senior counsel assisted by Mr. K. Kunitip, the learned counsel, Mr. A. Sharma, the learned appearing on behalf of the petitioner. The DKNR, DNA appears on behalf of the state. Swami appears on behalf of the private respondent. The petitioners herein have essayed the award passed in LA case number 192 of the 2011 and LA case number 193 of the 2011. Whereby the compensation have been worked out in terms with the right to fair compensation in 2015. It is the case of the petitioner that the approval that the land acquisition proceedings, which was initiated in the year 2011, it culminated with the approval being given by the Revenue Department of the Government of Assam. And for which Government of Assam, the year 2011, for which the petitioner was directed to make payment On the other hand, the stand of both the respondent state, the district and the collector, as well as the private respondent, is that there was no award passed, award made prior to, made in terms with section 12 of the Act of 1894 and Acquisition Act 1894. Prior to the coming into effect, prior to 1/1/2014, that is coming into effect of the Act of 2013. And therefore, the estimate, therefore, the award which had been passed in LA case number 192/2011 and LA case number 193/2011 in the year 2017 is the award. And as per the settled principles of law, the said amount is required to be paid to the private respondent. Ms. G. Goswami, the learned counsel appearing on behalf of the petitioner, the respondent, submitted that the acquisition which have been made by exercising the power of eminent domain by the state respondents for the benefit of the petitioner company imposes a duty, an obligation, custom, duty and obligation upon the state respondents to make payment of the dues, payment of the entitlement immediately upon determination of the said compensation. And delay in making of such payment affects the rights under Article 300A of the Constitution. This law, by an order dated 31/8/2024, by an order dated 14/8/2024, as well as on 31/8/2024, has sought for the records of LA case number 192/2011 and 193, LA case number 193/2011. Mr. Dina, the learned counsel, appearing on behalf of the district administration, appearing on behalf of the collector, have placed before this court the records. From a perusal of the records, it appears that the pursuant to the approval made in the year 2011, by the Deputy Secretary, by the Revenue Department of the Government of Assam. There were various communications issued to the respondent, to the petitioner company, requesting them to make payment. However, the petitioner company had issued certain communication to the effect that the compensation which was determined under the compensation the wherein it was mentioned that the compensation so determined was in excess and seeking a review. Under such circumstances, this court had asked Mr. Dinard, the legal counsel appearing on behalf of the collector, as to the agreement, as regards the agreement which is required in terms with section 39 and 41, 39 of the Act of 1894, and in the manner to be drawn up in terms with section 41 of the said Act, and in this, and so to be published in terms with section 42 of the said Act. From the records, such agreement could not be produced before this court. First, Mr. M.K. Chaudhary, the learned senior counsel, submits that he would like to obtain instructions from his client as to whether there has been any agreement entered into as per the mandate of section 41 of the Act of 1894. First, list this matter well.
Any economic your worship except 9th.
I'm also not there. Let's have it on 18th. 17th. What? Why? Don't worry. 17th. On 17th of December 2024. On that day, Mr. M.K. Chaudhary, the learned senior counsel, shall instruct his instructing counsel to obtain instructions as regards the existence of, as to whether any such agreement was entered into. In addition to that, Mr. Dinard shall also obtain necessary instructions. The records which were produced are returned to be reproduced again on the next day. I've given you time, madam. Think about what to do.
They were given enough time.
Page 30 is the impugned order. Now against this impugned order, my lord, the petitioner has filed an appeal before the secretary. That appeal is pending till now. Now, in the meantime, my friend, my lord, who are thought to be, my lord, implicated party respondent, they have also approached this honorable court by a separate writ petition that has been disposed of, directing the registrar to pass an appropriate order, the issue raised there. Now, if your lordship kindly see this order, my lord. My friend, my lord, who are thought to be implicated party respondent here.
Now, what is your case?
My case, I was a member of a particular society. Then I have resigned. After resignation, I have been appointed as a secretary by the board of members.
Very
Yes. Lordship will
Hey,
find,
Assam
Lord,
Cooperative Society.
page 18, Lordship will find. First, my resignation. Page 18
That
of
is
the,
your resignation.
yes, resignation, my lord.
23 is your appointment.
Yes. Then Lordship will find page, my lord, 20 is the, my lord, acceptance. Then Lordship will find page 23. Page 23, my lord.
Yes.
Resolution number 2. In today's meeting, the members of the BOD have thoroughly discussed regarding the appointment of the permanent secretary of the Kochim Mondia SS Limited, and it has been decided to appoint one Lokman Hussain, petitioner here, local educated youth, as permanent secretary under section 38(2) of the Assam Cooperative Societies Act 2007, amended up to date. That's his appointment. Then Lordship will find his appointment has been, my lord, approved by the RCS at page 26. Page 26,
Temporarily.
temporarily. Then in between, my lord, another resolution was taken by the board of members, my lord, whereby he was again interrupted. Then subsequently, another resolution was adopted by which the petitioner has been again, my lord, allowed to hold to act as a secretary.
Then?
That Lordship will find from the order passed by the Honorable Court in the earlier proceeding at page 34, Lordship will find. Page 34, third paragraph. Page 34, third paragraph. After going through the materials available on record, I find that although by the resolution dated 10/8/2023 and 12/8/2023, the Board of Directors had taken a decision not to implement the resolution dated so and so, meeting so and so, yet subsequently by resolution adopted in the meeting.
And
Board of
after
Directors
going
held
to
on
the
28/8.
materials available on record, I find that although by the resolutions dated 10/8 and 12/8, the Board of Directors had a decision not to implement the resolution number 2 adopted in here, that is for appointing you.
Yes.
Yet subsequently by resolution adopted in the board's meeting of 20, the resolution adopted in the meeting held on so and so have been cancelled.
And the resolution
And the
dated,
resolution whereby it was decided that I should be appointed as the secretary of the society be affirmed.
yes.
After going to the materials, prima facie appears adopted in so and so on Iman, appointing the respondent as the secretary has been restored. The order has been assailed by the president of the board by filing retrieval, whereas the same order has been another shareholder of the piece of this court that the interim order is appealable under section 100. President of the board have prepared an appeal before pending. Yes. Then
Yes.
the
Then,
court did
Lord-
not decide anything.
yes, matter was referred to the secretary. Then the impugn order, my lord, page 38. In the impugn order, my lord, without hearing the, my lord, petitioner, that was been issued, my lord, whereby last paragraph, Lordship will find.
But without hearing, the hearing is there.
Yes.
Paragraph 3. The hearing was
As per the
attended
notice,
by
he
so
went
and
there
so and so.
and,
and
my
Iman.
lord, he submitted an application, but nothing was, my lord, heard.
And then your presence out there is subject to the pleasure of the, you have no vested right.
Yes.
When when the power is there to remove also, then the power is there also, because you see, to nominate, elect, appoint or remove the chairperson of so and so. Provided he is not a government appointee. Then
Yes.
what right you have?
Yes, have. But subsequently, my lord, Lordship has seen subsequently resolution in my favor.
So what? That is good. That If there is a resolution to their favor, they can very well take another resolution, remove you.
No, my lord, subsequent resolution in my favor. Intermediate two resolution were against the petitioner, but subsequently lordship will kindly see page 34. It is reflected in the order itself,
Yes.
page 34. My lord, third para, my lord. Subsequently, by resolution
No, no,
adopted
there-
in the meeting
did
of
not-
Board of Directors held on 28/8/2023, the resolution adopted in
No,
the
no, the
meeting held on
court had
so and so
here-
has been
no,
cancelled.
sir, you kindly see.
These two resolution, my lord,
so and so,
10/8
14/8.
and 12/8, those two resolution against the petitioner cancelled, and the resolution dated 24/7/2023, it is in my favor, whereby it was decided that the respondent number 6 should be
14.
appointed as secretary of the society. This is in my favor. Now, contrary to the resolution, lordship has seen 28/10/2024 and 24.
Now you have a new body.
Yes, ma'am.
New body has come.
We do one thing, we interfere with this one. Thereby leaving it open to you. Take a decision as per 38. That's all.
Now,
And so far his appeal is concerned, my lord.
What appeal?
my appeal is pending
Against
before
the
the
order of the register, he
Secretary.
has filed an appeal before the complaint.
Then why you are here?
yes, space 40.
That is what.
Then why you are here?
He has
Since
availed.
no action.
No,
was
no, no,
taken-
why you are here?
But
Alternative
since no
remedy
action
is
was
available.
taken
You have
by,
filed an appeal.
yes, appeal
You
time.
go there.
Yes,
Nothing doing.
case 40, my lord.
You have filed an appeal. You
Yes,
can't
sir.
have so many avenues.
Yes.
Now, since no action has been taken by the appellate authority, we approach the Honorable Court.
So what?
Case 40, lordship will file.
That section 111, there is a provision for praying for a stay, my lord. That he can remedy, he can seek there. my lord.
You are not going to interfere with all this.
Case 40, my lord.
No, I heard Mr. M.U. Mondal, the learned counsel appearing. So and so appears. I don't bring you. So and so, MD Bora appears on behalf of the respondent number 2, 3, 4, 5. Gusto. Mr. JMA Chaudhary. The learned counsel appears on behalf of the newly implemented respondents. 16 to
25.
The instant petition has been filed assailing the order dated 14/11/2023 passed by the Register of Cooperative Society, whereby the petitioner whereby the Register of Cooperative Society held that since the Board of Directors of the Society was dissolved, the Officer on Management of the Society was asked to appoint a new Secretary of the Society temporarily in place of the petitioner who was suspended, and to hold the annual general meeting election of the Pachim Mandaya SS Limited as soon as possible. It was also observed that the appointment of a permanent secretary of Pachim Mandaya SS Limited, the next board of directors would take decision on the matter as per the Assam Cooperative Societies Act 2007 and the prescribed bylaws of the society. First, it is seen from the materials on record, including the application so filed, including the interlocutory application being IAC number 3610/2024, that in terms with the provisions of the Act of 2007, a new the respondent numbers 18.
My lord,
How much you were saying?
16 to 25, my lord.
16 to 25
Were elect-
have been newly elected as the board of directors of the Paschim Mondia SS Limited. This court have also taken note of the provisions of section 38(2) of the Act of 2007, whereby the board have been empowered to nominate, elect or appoint and remove the chief executive provided he is not a government appointee. First, in view of such power being conferred upon the board, it is the board who is required to adopt appropriate resolution. Who can, in view of the board, can very well adopt appropriate resolution to nominate, elect, or appoint any person in terms with the Act of 2007 as its chief executive. Considering the above, that during the pendency of the instant writ petition, a new board has already been formed, and the writ petition and the respondent number 16 to 25 have been elected as the board of directors, this court is of the opinion that nothing further survives in the instant writ petition. Accordingly, the writ petition stands closed. Nothing further survives. According the writ petition stands dismissed. Heard Mr. J.M.E. Chaudhary, the learned counsel appearing on behalf of the applicants. Ms. Lorenzo appears on behalf of the Corporation Department, and Mr. M.U. Mondal appearing on behalf of the writ petitioner. This is an application filed by the applicants who have been elected in the AGM held on 19 to 2024. Taking into account that the applicants herein are the present board of directors of the Paschim Mondia GPS Limited, and their rights under section 38(2) of the Act of Assam Cooperative Societies Act 2007 have been affected. This court is of the opinion that the applicants are required to be arrayed as respondents to the accompanying writ petition. Accordingly, this court includes the applicants herein as respondent number 16 to 25 to the accompanying writ petition. The counsel appearing on behalf of the petitioner shall file a memo of parties before the registry of this court within 3 days from today, and on the basis thereof, the registry shall make necessary correction of the records as well as also update in the CIs. In the circumstance, the petitioner does counsel for the petitioner does not file within the said period, liberty is given to the respondent, the counsel for the newly impleaded respondent number 16 to 25 to file such memo parties. Agar interim order vacate.
Timing item 19.
Yes. Withdraw.
Yes, sir,
Mr. S.
please.
Bonik, the learned counsel appearing on behalf of the petitioner submits that as during the pendency of the writ petition, the license have been renewed, have been renewed, the petitioner's apprehension is no longer there. Accordingly, the petitioner submits that he has instructions to withdraw the instant writ petition. The writ petition accordingly stands closed.
Petition item 23.
And Goswami appears for the Excise Department.
Yeah, please, Your Lordship.
What is this?
This is a writ petition challenging the order dated 21/9/2022
Why?
passed by the district judge Hailakandi under section 16 of the Indian Telegraph Act.
Why you are challenging her by way of a writ?
My lord, subsequently, this honorable court had converted the same into a CRP number. And then this honorable court had disposed it of it. Similar writ petition. There were 4 batch of it.
Yes, what are you challenging here?
My lord, the compensation granted by the Honorable District Judge Hailakandi, my lord, under section 16 of the Indian Telegraph Act. The main question in this matter is limitation, my lord. Our ground of limitation was taken in the written objection filed in 2006, Miss PG case 86 of 2006, my lord. The limitation point was not taken into consideration, neither the district judge framed any issue with regard to limitation. So, in the subsequent case, this honorable court had remanded it back to the honorable district judge for a fresh consideration on the point of limitation.
How much is the enhancement?
My lord, the enhancement is 38 lakhs 56,000. The awarded amount is 38 lakhs 56,500.
And
Before that, my lord, in the previous case, it was given 7 lakhs 3,600.
pay.
My lord, on the ground of limitation, my lord, the subsequent case was remanded back to the honorable district judge, my lord, by this honorable court.
Yes.
Except filing written statement, then neither appear nor adduce any evidence, even for example in the PW. Here is the petitioner examined as PW1 and how many documents he produced before the trial court, the district judge. And
When did you file the application?
application is at page 17. The page 18 lawsuits specifically stated when they denied, I approve.
When did they approve, deny?
Denied on lastly on lawsuit 28/9/2005
They denied.
and 3/10/2005 denied.
Cause of action accrued in the year 1999, my lord.
From denied to and there. Earlier after the issue.
We had paid the compensation amounting to rupees 5,179, my lord.
They admitted they have damaged our trees. And that list has been provided by the district authority. What are the trees they have damaged?
Let me see your
And rate also been placed by the authority also. Page 52, Lordship will find this number 3.
You did not appear.
My lord, we had filed a written statement. my lord.
So what? Why didn't you appear during the course of the hearing?
But it is evidence also.
Forget about
Not
everything.
evidence was adduced, my lord, but we had appeared.
Not examined the judgment, Lordship.
My lord, page 47. For the opposite party, she asked to call.
This is an application file challenging a judgment dated 21/9/2022 passed by the learned district judge Hailakandi in this case number 86/2006, whereby the learned district judge Hailakandi directed the petitioner herein to pay an amount of rupees 38,56,500 towards compensation to the petitioner. Compensation to the respondent herein. It is seen that the proceedings under Article 226 of the it is seen. Oh, very well. Why should I convert? One, you file under 226.
My lord, I had filed under 226 due to.
No, wait. You file under 226. If you file under 226, you consider that particular court not to be a civil court?
My lord,
Wait.
Fine.
If it is not a civil court, how do you apply Limitation Act 1963? So you dismiss your case.
Section 16 subclause 5, my lord.
Forget about that. If I don't convert it to 227, this is to be dismissed. Because you by yourself say that it is not a civil court.
Subclause 5, my lord. It says that the order passed by the district judge is final, my lord.
So therefore, you have come under 226. 226 against an order passed by a tribunal. Now the tribunal, you say it is not a civil court. That is why you have come under 226. And in that case, how will the Limitation Act 1963 will apply? You can't apply Limitation Act 1963 to any other proceedings.
My lord, we had approached under 226 just because of section 16 subclause 5, my lord.
You could have approached under 627. You did not. Why should I? Then how do I bring in 137? What do you say, Mr.
Yes, actually, Lordship is correct.
Yes.
That is, last professor I made submission in that other cases also.
So we dismiss on that ground.
16.5 says that every determination of a dispute by a district judge under section 3 or 4 shall be final.
I shall not convert. You have objection against conversion, no?
Yes, sir.
Let me give a short there.
Counsel appearing on behalf of the petitioner seeks for an accommodation. This is the matter of 4 weeks.
Next one.
And what about interim? Have you paid
My lord.
any amount?
My lord.
How much?
Interim is operating, my lord.
How much you have paid?
But that I need to.
You file an application
Yes,
for
sir.
modification. List this matter again. Is this matter again on uh 8th of January 2024. The interim order passed earlier shall continue till then. We file an application for modification so that some payment can be made 50%.
24.
Yes.
Your lordships.
What is your case?
Yes, 19 lordships. Lordships is, I got the NOC lordship, Satyavati Kakoti got the NOC in 2006 lordships for construction of G+4 building at 32 Harapur Gaon Panchayat lordships.
Huh?
Harapur Gaon Panchayat lordships. And accordingly, construction was done, phase 19 lordships, NOC issued by Harapur Gaon Panchayat lordships. Lordships,
What do
phase
you have to say, Mr. Naik?
Lordship, may kindly see the first order, not the last portion. Lordship directed him to demolish the illegally constructed portion within the next day.
Shall demolished.
They did not, Lordship, and accordingly,
They shall not proceed with the demolition of the illegal they have made in the land of the widow without the leave of the court, and that would be not be a bar to proceed with the proposed action after a month subject to further order. You have removed the illegal construction.
construction. Lordships, this, I approached before this honorable court, lordships on 24/7/23 lordships. And lordships in 24/7/23 lordships.
Mr. Naik, why are you not filing an affidavit?
affidavit we have not filed because thereafter Lordship court passed another until further order.
Order?
Until further order, the stay so far as stay is concerned.
Ah.
In the meantime, Lordship, we conducted the measurement, Lordship,
Ah.
and the authority has already submitted a report, Lordship. There we found some deviations, Lordship.
To bring on record. Okay. Mr. P. Naik, the learned standing counsel of the GMDA, admits that that during the pendency of the writ petition, the GMDA authorities have made certain measurements and found that that a construction so carried out, there are certain illegal construction being carried out by the petitioner. The GMDA is directed to bring on record the said's aspect by filing an affidavit. This matter again on 21/2025. Interim order passed earlier shall continue till then.
6.
Yes, what is this? What is this?
Regarding non-payment of contract bill, my lord, phase 25, my lord, can you see the combination?
Which department? APDCL?
I am the widow, my lord, my husband has died, my lord, I have a next year, my lord, next of kin certificate also.
Widow you are, but yeah, yes, none appears on behalf of the APDCL on call. Full stop. This court for the end of justice fixes this matter again on 22nd of January 2025. Full stop. The APDCL is directed to bring on record their stand by filing the affidavit by 21/2024-25. It is however made clear that if no affidavit is filed, this court shall dispose of the instant writ petition on the basis of the materials available on the court.
27.
The petition
What is this?
licensee of a fair price shop, your lordship. Her license was suspended in 2022. Thereafter, after 1 year, a show cause notice was issued. We have responded to that show cause notice. Thereafter, lordship, at page 31, there is a report that since it is a minor offense and it can be considered as the first offense and the license can be restored with a show cause with a warning.
Yes,
that-
yes, Mr. K. Gogoi. How is this possible? Understood. What is this? You issue a show cause, how can you keep a thing suspended for more than 90 days?
Only reason is that lordship, that trial is going on.
Huh?
Only reason is as per affidavit, lordship, trial is going on.
Trial is going on, whatever maybe you cancel it, whatever maybe you do, whatever maybe. But the question is, how can you keep a thing under suspension for more than 90?
Otherwise, the appeal provision is there, he is not exercised there.
Yeah, we help him. Gross violation. How is it possible? You
That
can
part-
keep beyond 90
that
days. You
part-
can't. Heard Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the petitioner. Full stop. The petitioner and Mr. K. Gugoi, the learned counsel appearing on behalf of the respondent numbers 1 to 5. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in and is aggrieved by the prolonged suspension of the petitioner's license, which is contrary to the mandate of clause 15 of the Assam Public Distribution of Articles Order 1982. From the materials on record, it reveals that the petitioner that by an order dated 8/7/2022, the respondent number 4 had suspended the license of the petitioner under clause 15 of the Assam Public Distribution of Articles Order 1982. Full stop. It is seen that there was a show cause notice thereupon issued on 12/10/2023. The petitioner submitted his reply on 16/10/2023. The record further revealed that till date, nothing has been done in respect to the said proceedings so initiated. And the petitioner had license have been kept under suspension. It is seen that pursuant to the filing of the writ petition, the affidavit in opposition has been filed, wherein it has been mentioned that an FIR has been filed against the petitioners in the local police station on 26/7/2022. And as such, and as such, in view of the said FIR being lodged, the suspension has been continued. Now, has it been charge sheeted?
Trial is going on as per of the Telegraph 18 law.
It is further stated that the petitioner have also been charge sheeted pursuant to the FIR, and there is a proceedings pending before the subdivisional magistrates court. Where? Guwahati?
At Huzai,
Guwahati, huh?
at Huzai.
Right.
Right.
Huzai. Huzai. This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondents. From a perusal of clause 15 of the order of 1982, it appears that the period of suspension is limited to 90 days. Under such circumstances, the question of continuation of a suspension beyond the period prescribed in clause 15 is not permissible as per the mandate of the said provision. This court have also duly taken note of that an inquiry was conducted also in terms with clause 15 by issuance of a show cause notice, and a reply also had been filed as far back as on 16/10/2023. However, nothing has been done by the respondent authorities. This court, upon hearing the learned counsels and upon perusal of the materials, is of the opinion that the continuation of the suspension so made beyond the period of 90 days, being in the teeth of clause 15 of the order of 1982, requires interference. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The prolonged suspension of the petitioner beyond the period of 90 days from 8/7/2022 is bad in law and accordingly stands interfered with. And accordingly, the order dated 8/7 and accordingly interferes. The petitioner, the respondents herein are directed to complete the state proceedings so initiated under clause 15 of the order of 1982, wherein show cause notice and reply have been also filed within a period of 15 days from the date of service of a certified copy of the instant order, or 15 days from the date of the instant order. I think better. 20 days from the date of the instant order. And while doing so, the petitioner be given an opportunity of hearing. And the respondents herein, a concerned respondent, the respondent, who is the respondent? Respondent number 4. The respondent number 4 is directed to complete the inquiry proceedings, which was initiated on the basis of a show cause notice dated 12/10/2023. Within 20 days from the date of the instant order. In doing so, the respondent number 4 shall pass a speaking order and also provide an opportunity for hearing to the petition. Number 3, basing upon the said with the above even this
28,
Yes, Mr. Ghosh.
Non-payment of contractual, they have completed the work.
PWD,
Completion certificate has been given.
PWD.
My lord, it was executed by the PWD on behalf of Health Department, my lord, Community Health Center.
Who is to pay?
Well, it will be the health department will have to make the funds to the PWD and it is there.
Then
Let it be on Monday.
Otherwise, it is admitted.
Why are you asking for so much on Monday, Tuesday and all? You take your time, file your apply. This is a 2024 matter.
Yes,
Yeah. Good stuff. Mr. B. Gogoi, the learned counsel appearing on behalf of both the PWD as well as the health department submit that he would like to bring on record the stand of the departments by filing an affidavit. List this matter on 5th of February 2025. In the meantime, the reply be filed by by 30th of January 2025.
Landless can take care of both the department, right?
39.
Landless can take care of both the department.
So that is why he is appearing.
There is sign up.
Yes, what it is.
Lots of notice because I have to file affidavit lots.
Huh?
Can you kindly allow me 10 days time?
What is this case?
Non-payment of contractor's bill.
Non-payment. You have not filed your affidavit.
10 days time to be.
Okay. Mr. Deborah, the learned counsel appearing on behalf of the health department. Takes time to file an affidavit in the matter. This matter again on 7th of February 2024. The affidavit be filed on or before 4th of February 2024. 25 days.
30.
This is also non-payment of contractor's bills. Lord.
Same.
They have not yet received the instructions. Lord. They have yet to receive the instructions. Lord.
You file your affidavit.
Okay. Obliged, sir. Obliged.
31.
Whether I file an IA for correction of the name of my father of the petition number 3 to 8. Instead of Nasir Ali Bepar, it should have been Muslim Adin for petition number
What is your case?
31 euro,
Father of the petitioner?
for 3 to 8. Instead of Nasir Ali Bepar, it should have been Muslim Uddin for petition number 3 to 7. And instead
What?
of,
I'm not getting you.
I file an IA for correction,
For?
correction of the name
For?
of the father of the petitioner number 3 to 8.
Father of the petitioner of 3 to 8. His name is what? Nasir Ali Bepari.
His name should have been Muslim Uddin. Yes.
Oh, dispose of. Oh, no. Huh? Make clear if the affidavit is not filed till date AR. Now what do you want?
I need a correction of the name of my father. Petition number 3
So you want to
7.
amend.
Yes, sir. Cause title.
So his name is what?
Muslim Uddin.
Muslim Ali.
Muslim Uddin.
Muslimuddin.
I've stated in my paragraph number 7 of my petition, Your Lordship.
From 3 to 8.
3 to 7 Muslim Uddin and Samsul Haq for petition number 8.
Why these type of petitions are filed in this manner? What is this matter for?
This matter is for correction of the land records, Your Lordship. What has happened is that my predecessor
File a new one. What is this type of petitions are filed?
in paragraph number 7, Your Lordship.
No, nothing doing. What is this? This is a case of amendment. Why will you ask for this for correction? File a new one. Withdraw, make a return. There's a mistake, formal mistake. Withdraw and file a fresh one. What is this, all these things?
In my petition,
Nothing has happened in the meantime.
in paragraph number 7, I have stated, Your Lordship.
Absolutely, we should dismiss on the given. These are false statements being made.
No, Your Lordship, in paragraph number 7, I have stated.
No. You are in the petition. You have said that you are the father of your father is different.
No, my father is Nasir Ali, my predecessor is Nasir Ali Bepari. My
Hmm.
grandfather is Nasir Ali Bepari. If Your Lordship takes up paragraph number 7, the repetition, Your Lordship.
Yes, government. What is your instructions? What is your instructions in this matter? Why you are asking for correction of the records?
What has happened is that Nasir Ali Bepari, my predecessor, was the owner of 101 bighas. And after coming of the Sealing Act, 53 bighas came under sealing surplus and 48 bighas remain in my name. I was paying land revenue. In the year 1987, when my predecessor Nasir Ali Bepari went to pay the land revenue, it had been stated to us that due to inadvertent mistake of the revenue authority, the land has been shown as government khas land. And I have
Now this as per 31/10/2016, as per Khotian number so and so, his name is there.
Yes,
Then
no,
what
not
the-
there.
Huh?
Not there. Thereafter, I filed an RTI application.
No, here it says, no, kindly see Annexure 4, page 25.
It should have, but my name is been not showing there, the land records.
Where?
It has been converted to government khas land. I filed an application, then I have filed RTI. That is the reply of the RTI, page number 25.
What?
I have preferred representations after representation for
Reference
collection of the
and
name.
then numbers of looking to report collection which are sent to. Yes, madam, why? What is wrong?
Circle officer.
Hello, you'll have the circle officer. Don't come up with these type of files. One person's father is okay or not?
Yes.
Okay.
One and
No.
two.
Don't require this matter. Madam, on the last occasion, we said that if you don't come up with your response, we are going to dispose it of on the basis of the materials on record. How is it possible? Mr. Kenugoi, this is not helping. You get the, oh, Mr. Hendik, you are there? Kindly get the instructions in so far as this respect. We are not concerned. Kindly come to Annexure 4, page 25. Herein it says that this land, 101 bigha 2 katha 15 lectures, was standing in the name of Nasir Ali Bapari. Ceiling, fixation of ceiling act, 48 bighas still remain. And as per the Khatian, it still remains in the name of so and so. Did you apply for the certified copy of the Khatian?
That instruction, yes, your lordship.
Where?
Certified copy I do not have. But I have a Xerox copy.
No, Mr. Das, kindly see. Have you seen the serial number 5?
Yes, your lordship.
Certified copy of the Khatian may be obtained from the other side after submitting separate application. Did you
That was-
submit?
That was obtained, yes.
You have the Khatian.
Yes, your lordship.
Where is it?
That is not in the record, your lordship.
No, that means it is must be there. Otherwise, how did he give this report? So, Mr. J. Hendik, the learned counsel, appearing on behalf of the district commissioner, Dhubri, shall obtain instructions. I placed certain instructions before this court. However, the issue involved in the instant case pertains to the Khatian number 247 of village Nayarala, Nayeralga, part Roman 2, wherein 48 bighas 4 katha 2 lechas still remains in the name of Nasir Ali Bipari, who is the predecessor in interest of the petitioners. It is the specific case of the petitioner that such under such circumstances, this court directs the district commissioner, Dhubri, to place before this court the Khatian number 247, the above mentioned Khatian, a copy of the above mentioned, a certified copy of the above mentioned Khatian number 247. List this matter again on 24th of January, 2025.
32,
No, very good. Yes, Mr. Upadhyay, non-payment. You don't want to pay. Then what is your instruction? Mr. N. Upadhyay submits that he is yet to receive the instructions in respect to the matter. This matter again on 10th of February 2025. In the meantime, the Irrigation Department is directed to bring on record their stand by filing the affidavit on or before 6th of February 2025. It observed that if there is a failure to do so, this court shall dispose of the petition on the basis of the materials available on record.
33,
Instruction is yet to be received.
Huh?
Instruction not received, ballot. I will file an affidavit. Instruction not yet received.
Mr. S.K. Talukda appearing on behalf of the Corporation Department submits that he is yet to receive instructions in the matter and seeks some time for filing the affidavit. This matter pertains to what?
In fact, the registrar has found ballot some tampering in the ballot paper. Thereby, ballot, he has set aside the election ballot.
This matter again on 18th of December 2024.
January month.
Absolutely no. Somebody's right. Election. You have it Friday?
Correct.
Friday?
Correct.
On 18th of December 2024. Pustup, the affidavit be filed by the Respondent Corporation Department by 13th of December 2024. Pustup, on the next day, the records also be produced in respect to the order dated 24/1/2024.
34,
Yes.
If they are yet to file the affidavit in this matter, that is against the impugnment order, which was passed without considering of this supposed notice, supposed reply filed by the petitioner lordship.
But here the instruction is evident when it can be after 2 weeks.
Mr. B. Gogoi submits that some time is required for bringing on record the stand of the respondent department. First, list this matter again on 27th of January 2025. Interim order passed earlier shall continue till then.
35,
Yes, what is this?
Their application for confirmation of delay, filing the refund application was rejected.
Huh?
Their application for confirmation of delay, filing the refund was rejected. Basis upon notification 9 of 2015. It directed me to obtain instruction, but I require some more time.
You need more time. Mr. S.C. Kyle submits that he requires some more time to comply, to obtain the instructions as sought for in the order dated 8/4/2024 and 8/5/2024. This matter again on when?
2 weeks. After 2 weeks.
This matter again on 13th of December 2020.
Much better.
On which date Mr. Kyle shall obtain the instruction as
36,
directed without fail. Without fail. Yes. Anything filed? Against the suspension of the fair price exemption of the sale by the petition and the suspension, still continuing,
Let me cancel.
cancelled. This is challenging the suspension.
No, they have challenged the suspension order, they have to challenge it first.
The instant writ petition has been filed challenging the suspension order dated 8/1/2024, passed by the suspension. The appeal of the petitioner filed on demand before the where is that order?
There is the order of the Honorable Court on 8/4/24 in this petition.
Okay, okay. The petitioners herein have assailed the orders dated 8/8/2023 and 3/11/2023 passed by the respondent number 5. Whereby the petitioner's retail license bearing number 3089 under MS Sonapur Cooperative Society Limited was suspended. Mr. K. Gogoi, the learned counsel appearing on behalf of the respondent, submits that pursuant to an inquiry being conducted in respect to the petitioner's license, an order is passed on 15/5/2024, whereby the petitioner's license have been cancelled. Footstep. Whereby the cancellation of the petitioner's license was upheld by the an order dated 15/5/2024 by the Deputy Commissioner, isn't it? Cancellation of the order, no? The oh no, good stuff. Mr. K. Gogoi, the learned counsel appearing on behalf of the petitioner, submitted that on 3/11/2023, the license of the petitioner was cancelled by the respondent number 5. Pursuant thereto, an appeal was preferred before the District Commissioner Kachar by an order dated 15/5/2024. The said appeal filed by the petitioner was dismissed. A copy thereof have been placed before this court along with the instructions. Taking into account the above, nothing further remains in the instant writ petition. The instruction so placed is kept on record and marked with the letter X. Accordingly, the instant writ petition stands closed. Liberty, however, is given to the petitioner to challenge the order dated 15/5/2024 if so aggrieved.
Happy. This is a matter pertains to the formation of a legal committee for the Jal Jeevan Mission, where the president has been made a party as a private party, and they have made their affidavit, and they have stated in the page 77 of their affidavit.
Fight between you and him as to who is the main committee for water, what PHE?
For the ESPHE is the department.
Where is the PHE? No PHE. None appears on behalf of the PHE on call. List this matter again on, we have it next week on 4th of December 2024.
58,
This matter relating non-payment of compensation. Has my husband died due to electrocution?
None appears on behalf of the APDCL on call. Full stop. The learned counsel appearing. Full stop. It is also seen. Yes, yes. Government. Where is the electrical accident report? It is also seen that the respondent number 5, though directed, have not placed before this court the electrical accident report. List this matter again on 8th of January 2024. The respondent number 5 is directed to bring on record the electrical accident report pertaining to the incident.
39,
Here the petitioner is challenging the imposition of interest, your lordship. In fact, my lord, by amending, my lord, inserting. By, by inserting, my lord, section 128A, your lordship. And central government has amended, has waived that interest part. But my lord, state yet to amend their act. Against the state.
It may not. State is more. They want money. What is the affidavit?
Lordship, I paid for some time. I paid for some time.
How much?
2 weeks.
Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondent, submits that he requires 2 weeks' time for obtaining instructions and filing the affidavit. List this matter again on 18th of December 2024. The interim order passed earlier shall continue till the next date.
51,
Non-payment of fees.
Yes, Mr. Bottagu, what is this?
Here, your
This
lordship,
is the last order.
What is being challenged here?
lordship, the petitioners were directed to your lordship supply dumpers, your lordship, at a particular rate, your lordship. Now, your lordship, I supplied and raised bill, your lordship. Now they say that now in the market, it is available at a lower price, so I will not pay you. Now there are a number of contractors, your lordship. In fact, this honorable court passed an order, your lordship, in respect of one contractor, your lordship, whereby said that cannot be a ground to refuse to pay my bills. And accordingly, they were directed and they have paid to other similarly situated contractor, your lordship.
Oh, you got similar orders?
Yes, your lordship. That is at page,
Now,
your lordship will kindly
the
come to
committee has
page
been
36.
The committee has been constituted. The committee has been constituted on 15/10/2024, and a first meeting was fixed on 15/11, but it could not be held. Now, this meeting is coming up on this week, my lord. Let that meeting be.
Your
a
lordship, may
conclusion.
kindly for a moment peruse page 36, your lordship, order of this honorable court, your lordship.
Yeah.
Lordship, page 36. During pendency of the release petition, respondent number 1 to 5 had filed counter affidavit internally containing that dumpers of higher capacity were available in the market on higher at ₹6,000 per day. Therefore, rate claimed by the petitioner was exorbitant. Since public money is involved, payment of this petitioner, the respondent is deemed to verify the claim and figure by the petitioner is charging exorbitant rate. Now, your lordship.
Mr. Bora, if you don't give us anything, how can we hold anything else other than what the coordinate bench have held?
But we will fix after 10 days. Let the committee take a decision, man, after the lordship will pass.
I'm not there. I'm not concerned with that. But the fact that isn't it required for you to bring on record your stand by filing an affidavit?
That can
If
be
you
done, but
don't
only thing
bring
is
on
that it has been
record
sent to
that
committee.
stand, can this court differ with what my coordinate bench have held? It's some materials, otherwise
That
why
I will file my
shouldn't I?
affidavit, my lord. File my affidavit, my lord.
Yeah.
Within a week.
Mr. Ezbora, don't come up with all these things. These things, verification, no verification is hardly matter. We are not concerned. There's a coordinate bench order passed categorically saying that you cannot resile from once you have issued the work order. You are to pay. So, you have to pay. And you have paid others also.
Yes, Your Lordship.
You have brought in. Then why you are paying?
But there is the order
You don't like the face of the petitioner.
Well, let it come after a week, my lord.
Something must be the case.
It come after a week, my lord.
Mr. Ezbora submits that he has already received the instructions and he would like to bring on record the stand of the GMC in the matter. For the ends of justice, this court adjourns the matter today to be listed again on 4th of December 2024. The affidavit be filed by 2nd of December 2024. Failing which, this court shall shall decide the instant petition on the basis of all the materials already available.
42,
Lordship, in this matter, I'm in a very sticky wicket. I just need 2 days time to see if I can wriggle out somehow.
Yes.
I have an official.
Oh, you don't have a case, nah? When I issued the notice only, you said that you don't.
Lordship, I'll see if I can wriggle out just 2 days.
Yeah, I was very kind enough to issue a notice. You did not object. I had objected then also.
I have the court to deal with.
What is your case? Still, I forgot. Compensation.
Yes.
There are cases that Oil India has acquired a land by way of a sale deed through the power of attorney, their constitutional power of attorney. But later on, they are now raising a dispute saying the money was taken by the power of attorney holder and not given to the original owner. So if this is a
No,
situation,
and they
a
were
private
saying they-
dispute, it has to be decided by a
No,
trial court.
Lordship, the point remained, it comes because there was in
They don't disagree with the sale deed. They don't disagree with the sale, the transaction. But they say the money was never given to her, the original owner. She is
No.
claiming that.
No, the Oil India also took an indemnity for them. So we want Oil India to revoke it.
Then
So
You
the
don't have a
indemnity will
case.
come if the sale is found to be defective. Only then the issue will come in, not now. It's bit for a trial.
How long it has happened?
And-
22.
When did the sale happen?
Sale did happen in
And the Lordship, they-
2022.
I don't
Pursuant to a
lose
sale
any further-
agreement. The sa-
Don't
and
lose any further time.
NOC, sale permission.
I think you need to file a suit. Tomorrow, I am very kind enough to condone this period from 22/7/2024 till date for the purpose of limitation. Nothing more than that.
even that is fine, Lordship. I guess I have to.
At the end of the day, you have to.
Yeah, I'll
It is
have-
only
I'll have
Private dispute.
because yes.
Not been brought to.
Unnecessary now.
As your Lordship wishes. I think they.
That day I issued notice, it's okay.
I think I should know when to walk back.
Let these councils also be also engaged. That is the purpose. Heard Ms. M. Hadurika, the learned senior counsel, assisted by Ms. S. Newar, the learned counsel, appearing on behalf of the petitioner. Each appears on behalf of the. Madam, you,
Oh, this judge.
two Bachchaji appears for the respondent number
This one is number 5.
5. The J. Hendy appears for respondent number 4. The dispute raised in the instant proceedings pertains to certain amount which the respondent numbers 1, 2, and 3 had paid to the respondent number 5. The case of the petitioners herein is that the petitioners actually ought to have received the said amount and not the respondent number 5. The counsel for the respondent number 5, on the other hand, categorically submits that on the basis of the materials on record, it would be seen that the petitioners herein have no right to receive the amount. Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 submits that the said respondents have nothing to do with the matter, taking into account that on the basis of the power of attorney, the said amounts have been duly paid. This court, upon hearing the learned counsels appearing on behalf of the parties, is of the opinion that this matter is primarily a civil dispute between the petitioner as well as the respondent number 5. Full stop. Because under such circumstances, such adjudication of disputes in this public fora would not under such circumstances, this court is of the opinion that this writ petition is not a fit case for being entertained. Full stop. Accordingly, the writ petition stands dismissed on being not entertained. However, the petitioners herein would be at liberty to file a civil suit before the competent court of jurisdiction, and the dismissal of the instant writ petition on being not entertained shall not prejudice the petitioner. In addition to that, the period from 24/7/2024 till date be excluded while computing the period of limitation.
43,
Yes, what has happened? What a past?
No, my lord, there were some health issues and all, my lord. It's been pending. It is under, hearing has concluded already, my lord. And this judgment is under process, my lord. May I pray for at least 2 weeks' time, my lord, it will be delivered.
It has been submitted by Mr. A. Bhuyan, A.K. Bhuyan, the learning staff. Of the respondent number
1 and 3.
1 and 3, that the hearing had already been completed and the judgment is, and the order is required to be passed. He submits that within a period of 2 weeks, such order is likely to be passed. So taking into account the above, list this matter on 18th of December.
item 55, supplementary.
Secretary of School has given his detailed report.
Oh, the school, na?
Yes, Your Lordship. It is within the campus.
I draw your kind attention in respect to the shops situated in the campus of a school, 1 optical shop, 2 pawn shop, 1 scooter garage. What are you selling?
But say one is a tire shop, my lord.
Yes.
It's there in the rent agreements, my lord.
Scooter shop, scooter garage.
Yes, my lord.
Yours is scooter garage.
Yes, my lord.
How many shops are here?
3, my lord. 3 petition, my lord.
One
Well, the others are selling what?
Lordship, the first agreement, Lordship, will find at page 16.
No. Tell me who are selling what? Very serious. John Medi is selling what?
John Mehdi, my lord.
What are you doing?
Motor parts and electrical goods.
John Medi. Then number 2.
Number 2 at page 20, my lord.
What are you doing? $200 square feet. What you are selling? Pawn shop? Huh? Pawn shop?
No, my lord, no parts.
What shop?
Just a second.
There are 4 numbers of shops within the campus of our school. That is 1 optical shop, 2 pawn shops, and 1 school garage. The owner of the said pawn shops are selling liquor, vodka, cigarette, tobacco, etc. as a result of which students of our school are using so and so. Why we should not direct them to pay certain amount to the government, to the school authorities for the purpose of rehabilitation. We can adopt this.
My lord,
We ask you to pay certain amounts as compensation for rehabilitation of the students. Whenever they go to rehabilitation centers for the purpose of having cigarettes, gutkahs, you pay.
my instruction is that they are not selling any tobacco items, my lord. If they are any selling, that is not within my knowledge.
Well, I'm not knowledgeable.
One is motor part, my lord. One was a cloth house, my lord. And lordship, as per this madrasa education provision,
Wherever they are, go dude, wherever it is. This court is not going to permit all these things.
ultimately, my lord, our government can otherwise lend out properties. There is a may not be a bar. But thing is that whether an educational institute can
First of all, inside an educational school, you have
It
no
is
business to
within-
have these shops.
But my
Puta
instruction
garage,
is that
pawn
as
shop,
per a rent
affiliation.
agreement, it is specifically mentioned as outside. Lordship, kindly
within the
pay.
campus.
Yeah. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. P. Das appears on behalf of the Secondary Education Department of the Government of Assam. Madam, didn't I ask the inquiry report from the
It was the
inspector
the
of schools?
Yes, your lordship.
Huh?
Inspector of the school.
That the commercial is not permissible and it has been so and so. In the meantime, the report of the inspector, which was directed by communication, being placed before. Where's the inspector of report?
Here, your lordship, he is the headmaster of in charge.
Is
Inspector
he
in
the
charge,
inspector?
Habibur Rahman.
Is he the inspector? And we have to call the director of secondary education and help it. I think
Here, your lordship, headmaster in charge has given this letter and addressing to the inspector of the school, your lordship.
whatever may be, the report has to be given by the inspector, isn't it? In the meantime, the report of the inspector, which have been directed by the communication, be placed before this court. What is wrong? And kindly give this report in a better manner. You have to say where the petitioners are. Are these petitioners selling it? Madam, kindly appreciate. There are 3 petitioners here.
There are 4
Which
shops.
petitioner is selling pawn shop? Pawn shop.
Yes, your
Who is selling the scooter garage? Who is having the optical? Why are not names are given?
lordship. I have already communicated it, your lordship, because they are again and again doing the same thing. your
You
lordship.
communicate in English, you communicate in Assamese, or maybe in whatever language they may understand. But do something. Next week, this week, Friday.
Yes, sir.
Friday, we need to close this,
Yes, your lordship.
but you get it. Pursuant to the directions passed by this court on 2011-2024, Ms. Pidas have only placed before this court a communication issued by the headmaster in charge, Guwahati High School, to the inspector of schools, Kamrup Metro. However, this court has specifically directed the inspector of schools to place the report. Accordingly, this court fixes this matter again on 29/11/2024, on which day Ms. Pidas shall place before this court the report so sought for. In addition to that, in the said report, it has to be categorically mentioned as to where the location of the petitioner's shops are and what is the business being carried out by the petitioners. The said report be placed without fail. Madam, kindly do that.
56,
appears on behalf of the petitioner, lists the matter of reports.
That's item 44.
After that, petitioner was spent time by the judge for giving instruction.
None appears on behalf of the petitioner on call. Very appear. That the service cannot be effective upon the respond number 3 and 4. 3 and 4, no?
No, I appear on behalf of only respond about 2 lawsuits.
Respond number 3 and 4. In view of the wrong mentioning, in view of the fact that for the reasons so mentioned in the order of the laws in the court, the counsel for the petitioner is directed to take appropriate steps after 6 weeks.
45.
Yes, Mr. Bhattakur.
Subsequent to the last decision, we have been informed that the head of account has been approved by the Accountant General's office. So now a head of account worship to release the funds for the petition that has been approved by the Accountant General. Now Lordship will send a fresh proposal to the Finance Department and
Payment for what?
for contractual bill,
Contractual bills. The I Bhattakur appearing on behalf of the respondent numbers 1 and 2 submits that a head of account have already been approved by the Accountant General, and further steps are being taken for the purpose of dispersal of the amount. This matter again on 18th of December for an update.
46.
Thank you, Judge. Was as per order dated 25/10 of the Lavazim of services complete upon the private respondents. We have taken custody. What's
Service complete.
service complete.
Service is complete. This matter for admission on. What is the matter about?
So we are against the inaction of the authorities in demarcating our land. We had been.
Why there is an interim order?
Because there is an interim order to maintain a status quo.
Huh?
To maintain a status quo in the land.
Why is the interim order?
Because what had happened was there were 2 parties. The land belonged to the father of the petitioners. He had gifted it to one of his friends. So there was a separation, mutation was done and separate
This
pattas were.
matter on
But-
10th of January 2024, interim order partially shall continue till then. For admission, huh?
47 and 48.
Service being complete, believer. Service being complete, this the matter. 47, 48. Service complete.
Ballot in this case, there are 240 bighas of land were settled in favor of 59 persons and the government who are landless people. Thereafter, another 32 persons were left over. And they were then, out of these 240 bighas, 103 bighas of land was allotted to these 32 persons.
No, Mr. Mohammed. Today is a question of service. Service is complete. So we have it for admission. When? That is the question. Service being complete, list this matter for admission on 24th of January 2025. Full stop. In the meantime, the parties are directed to complete their pleas.
49,
What happened? What did I do?
So in this case, today we have filed an application, my lord, for vacation of the earlier order dated 1/5/2024, my lord. That in this case is perhaps not in record.
What review?
Review of my lord judgment dated 4/8/2021. And without there being any condonation for delay, my lord, and without there being any materials in the petition.
Oh. Naveen Goenka. Who passed the order? Okay. What is the direction? No such move initiated in multiple plans. What is this? I am saying that the land, even if they are no legal. Yes, where we file the review?
Because this order cannot be complied with. For the reason, my lord, that if you go to the merit of the case, my lord, that the writ petitioners, they filed this writ petition because of the fact that, my lord, the necessary permission for sale of the apartments over the part and parcel of land that was not given by the deputy commissioner. Now, the fact remains that the land is originally a TPJD Patka land. Now, that was not changed. The classification of the land remained as it is. But nonetheless, the deputy commissioner out there had issued permission. Then, my lord, the builder came up. Builder took up the project. And my lord, multi-story apartment was almost built. Then when at the time of my lord, he wanted to sell out the respective flats to the prospective customers. Then the problem arose. Then they came up before the writ court, and the writ court ordered.
What are you? Who is the builder? You are a builder.
Yes, ma'am.
You are a builder.
Yes. The builder is also the attorney, my lord, of the writ petitioners.
Okay, so you are the builder, so you want to construct.
I have already constructed, ma'am.
How did you construct on a T Patta land?
No, that is what, my lord. What happens? The land belonged to originally, my lord, Jalan Tea Estate, my lord. Jalan Tea Estate, my lord, sold various plots of land, my lord, to various.
Without converting.
But that is the point, my lord. The deputy commissioner, my lord, has given my lord, permission for sale permission already given in 2003. So I am the second owner, my lord. Now, my lord, in 2003, my lord, I have purchased with due permissions from the deputy commissioner and also obtained permissions from development authorities and all, my lord. And subsequently, a apartment was built, my lord. After the apartment was completed, my lord, so when the individual customers, my lord, they have invested, my lord, they have taken loans, etc., my lord, and their sale deeds is, my lord, not happening, my lord, because of the permission not given from the deputy commissioner saying that the land belongs to periodic land, my lord. Whereas, my lord, the learned, my lord, honorable single judge, my lord, while delivering the order, judgment, my lord, relied on executive instructions that is relied by them only, my lord. They have filed an affidavit in opposition, my lord, the deputy commissioner of Dibrugarh, relying upon an executive instruction dated 26/3/2001. By that, my lord, it says EVD which is a T-periodic land, my lord, that can be converted to Khirasmiadi for other purposes, my lord. And that is the way, my lord, the judgment was delivered, my lord. Kindly see, my lord, page 161 of the review petition.
Then
So, my lord, only
this is
thing
done by this Kedas or Cikedas.
Cikedas, yes,
Remember.
yes, my lord.
Now,
Because before the report, only one affidavit was filed by the deputy commissioner. And this notification was a part of the affidavit, which lordship will find at page 160 of the review petition. That is a part of the order. Now, this notification says, my lord, that despite of there being several earlier notifications and mandates, as well as wireless transmission messages, thereby restraining the deputy commissioners that you cannot give sale permissions as a routine matter, but things were being done. So therefore, this notification came to be issued, my lord, in the year 2001, whereby stricture was imposed only because of the fact that, my lord, if this order is allowed to be complied, then it will be in violation of the provisions of the 1956 fixation of ceiling. That is the only limited ground I am in.
violation of
Violation of the provisions of, my lord, the 1956 Ceiling Act. Because Ceiling Act, under the Ceiling Act, there is a specific embargo. Because if the cultivation has to be there, my lord, periodic cultivation, only the ceiling surplus will amount only with relation to the factories and other buildings. Lordship is aware. Now, so far as the real time tea cultivation area is concerned, there is no limit. So one can extend, but one cannot sell away the tea cultivation area.
But Mr. Bordugari, how do you bring the 56 Act?
So 56 Act, because admittedly this land is a tea periodic patta land, which is meant for tea cultivation.
Yeah.
Now it is being used for
No,
residential.
6 Act will come into picture to the affair. But they have filed the returns. And pursuant to that, these are the areas which have been specifically permitted to be retained or not touched on the ground, that these fall within the area of land of special cultivation. Therefore, you pass an order, final statement 7. Subsequent thereto, they pass an order, they sell it. How do you say that it is in violation to 56?
So 56 is one aspect of the matter. There are other provisions, statutory provisions, which are to be found in, my lord, the 2015 Land Classification Act. Because the classification as such is not changed. It remains a tea periodic patta, unless and until, because if this is allowed to go, all the tea gardens, they will start, my lord, selling their lands.
You knew about it then.
So if we knew about it, but
Becoming clever later on.
my lord,
Is it becoming clever later on, a ground of review?
no, my lord. But
Or
apparently,
a specific, a better advocate coming into the scene is a ground of review. I remember there is a very beautiful judgment in Lily Thomas. File appeal, but how is the case of review?
review, my lord, on the ground, my lord, that because error apparent on the face of the record, of course, I will satisfy your lordship. So because of this,
No, my lord, that cannot be an error apparent on the
Well,
face of
there is
the
no error apparent.
record.
It's a case of review,
any
not
other
a case,
ground-
maybe a case of appeal, but
Yes,
not a
sir.
case of
Case of
review.
And my lord,
File an
I am
appeal.
the third leg of that review jurisdiction, any other sufficient cause. But of course,
Any other
any
sufficient
other
has
sufficient
to,
cause has to be
again,
analogous with the two. It has to be analogous
again,
with
it
the other two
brings
parameters.
this
Yes,
court to remember that 1923 to be considered.
but
Any
apparently,
other sufficient cause has to be found there.
no, but here what has happened, because this order cannot be complied.
My lord, not a single whisper, my lord, in the
If
review.
it
petition.
cannot be complied with, it's not a case of review. The case of appeal. It's a case where they may go for contempt.
Yes.
They are,
The contempt, if they file, then you have to say that I can't pass that order. Why?
so in the contempt proceeding, we have filed our affidavit to the extent that this.
But it's a
order
contempt
cannot
on-
Yes, contempt is pending, my lord. They
Contempt
have
is
said, my
pending.
lord, because of the review, my lord, he cannot, that order cannot be implemented. They take the contrary step here.
Sir, I should not further paying you people.
Lordship may be pleased to fix this matter or some, because they have also filed an IA. Let it come, my lord, Lordship will decide, my lord. Lordship will
Let it
decide,
come up next week.
my lord.
Let it come up next week. I'm
My
not
lord, I
here.
am little, no
I'm
problem,
not
my
here.
lord.
Wednesday,
Okay.
my lord. Next month.
Huh?
Wednesday, my lord.
Next Wednesday.
This Wednesday.
No, see his state of affairs.
I'm ready. We can have it, my lord, on
Then Friday, my lord.
Huh?
Friday.
No, you see, this has a very important aspect. Yes, 226 review may not be there. The review doesn't lie out here. But it has a lot of implications in touching on the question of periodic pattas being sold. In fact, with due respect, the order should have taken into consideration. You may not be aware here, it's in your case, it is okay, you are suffering. But if such orders are being passed so lightly, it will have far-reaching consequences all over in Assam, more particularly in Upper Assam, where lands were being sold. There are far-reaching consequences. You can just give it. You see, this notification which was issued by Sikeda was only in respect of selling of tea gardens. And what was happening, these tea gardens were being sold with the DC's permission, and DC used to give it. The government said that you can't allow these type of selling which is being done. That is what it was saying, the tea gardens are near. Then these tea gardens adopted another measure, demerger. So this is used to be there, how it is. But the problem which arises here is, this has far-reaching consequences, these type of orders. But it is not a case of review.
I will try to persuade.
They submit one.
I will try to persuade.
In that area, my lord, since 2001 onwards, my lord, the huge land for plot of land has been sold to different persons. It's not only me, my lord. There are
No, Mr. Chakravarti, that is not the question. I know. I am from Dibrugarh. I know where your land it is. This is where it is, the land is just after crossing Don Bosco and all. This is the area of the land, isn't it? So there where you have the big markets on the road, which is there. I know this. But the question is, this is not here. There's a huge chunk of land out there just next to Tejpur. There's a huge chunk of land just next to Moran. All these places are now developing. Now these lands have a particular value. You can't compare them with a periodic patta value, because these are land for special cultivation given only for that, for which various acts. You don't bring the Assam Temporarily Settled Area Tenancy Act. You can't bring the Assam Fixation of Land Ceiling Act. All these acts are out. So under such circumstances, one has to be very careful in giving these type of permissions. But they have done it. It's a different, but not the case of review.
Because at that point of time, the deputy commissioners used to do it. So therefore.
Not the case of review, Mr. Bhavda. But today I'm not going to do all this matter again on Mr. A. Chakraborty, appearing on behalf of the respondent, oblique petitioners, expresses urgency in the matter. Full stop. Lists this matter on 4th of December 2000.
Can it be on 3rd of December with all respect? ma'am?
3rd is Tuesday.
You can hear it, my lord.
I am not here. I am not here for 2 weeks. That is why I'm fixed.
Fourth.
Item 50.
And so,
Yes, what is this? Who is appearing? Ah, oh, yes. What happened to the money?
Unfortunately, I have filed an affidavit. The executive engineer has been given a second show cause. Similar lines with contempt case 419, which your lordship has heard.
We do one thing. Kindly give us the head of account of your department expenses. List this matter again on. Let it come back when I am there. 16th of December 2024, on which date Mr. Ipo Thakur, the learned counsel, shall place before this court the head of account of the PhD department. We
51.
attach it.
Bless you.
Yes, what is this? Item number? Service complete? Yes. Service complete? No. Service being not complete is the matter of the completion of service.
57.
In this case, your worship, in
The
respect of
petitioner is
respondent-
directed to take appropriate steps.
Lordship, I have some submission. In this case, your lordship, respondent number 1 service has been completed. But in the meanwhile, your lordship, respondent number 2, that is Deputy Commissioner of Kamrup Metro, has been transferred. Therefore, survey as per office note dated 21/11/2024, lordship.
What is this matter about?
Matter regarding non.
Non-payment.
Yes, lordship.
Yes, Mr. Mr. Bopade, what is it?
that my lord, non-payment of 2 lakhs rupees in pursuance of an order for that motor accident ex-gratia.
But you can't now, these are my orders which have been passed earlier.
So first, we have to comply. I am appearing on behalf of R1. So I need to take the instructions, my lord. I need to take the updated instructions.
Take it in.
Respondent number 2 already transferred, so I may allow to amendment cost title, your lordship.
Have to kind of formally implement application. To contempt.
Not necessary. Mr. Arbopudari, appearing on behalf of the respondent number 1, submits that he will obtain instructions as regards the compliance to the order dated 17/7/2023, passed in WPC number 4327/2022.
My lord.
Matter again on 8th of this January 2025. Mr. Bopudari, kindly by 8th of January do something. Get this thing done.
It's okay, lord. It will be done. I am obliged, madam.
Service upon the respondents being complete, list this matter. Admission after 4 weeks. Oh, yes.
59.
Last item it has come. Why?
Yeah, please, Your Lordship. This matter was urgently listed. Your Lordship has given an order. to
Yes, what
convert
is the order
premises
being
into
passed by this court? Let us see.
Lordship's order is there at page number 12 to 13. And there is a specific order to convert the premises
Carry
to
on
commercial
present
within 3 months.
commercial activities in the said building being house number so and so till 31st October. Pursuant thereto, if the respondent number have not been for the use of the building from residential to commercial, cannot operate its commercial activities of distributorship in the name of so and so. This. Madam, no. No. Nothing.
Lordship, I have already applied.
Absolutely no.
No, to the person to engineer is there. I have applied there.
Oh, what?
His father suffered with.
No, no,
cancer.
don't. You, it has to be sealed. You apply. Now you cannot. This is absolutely on last occasion. I gave it only for a particular period of time.
Yeah, there was no intentional latches on our part.
Oh, no.
We have already handed over the
Or
paper,
Miss
Lordship,
M. Kumari,
and the
the learning
premises
council,
of
I'm
the
dismissing
document.
your petition. I'm dismissing your petition. If I dismiss your petition, you will have a big problem. So I don't think you should. You better off. I'm not going to do this. You apply, then they may give it, and
we
after that
applied.
you have to. Now it has to be
Applied
seen.
the
Have you
GMP
seen
also.
it?
Listen, sealing it,
Seal it. Are they
They have already
continuing?
sealed it.
You are
We
still
have already
continuing.
applied, Your Lordship.
they applied.
We have already.
No, no,
applied.
madam, are you still continuing?
No,
The statement is they are not continuing. Statement is
no,
they are not
we have
continuing.
voluntarily closed
Voluntarily.
because it
It
is
will be
delayed.
closed.
So
You apply, you get it, then you do it.
some
till then you
extension of
can't.
time is required.
I gave you only for, you see, it's presently carrying on the business and some time would be required to take approval for conversion. As such, submitted by the council, but there some time will be required. In the opinion, 3 months from today would be a reasonable period. So you apply.
So it was not delay on our part. We have already given there to.
So what?
His father
You,
suffered with
so
cancer.
what? No, nothing doing. You submitted much after that. This order was passed
Even
long
the
time back.
process of the
This
GMP
order was passed. You should have submitted. Why did you submit so late? I gave you 3 months
was
time.
not late on our part.
Anyways,
We
what
have
do you
given
want?
to the
Dismiss.
registered engineer.
Dismiss. This matter was disposed of, na? Okay.
On
Chalo.
24/7.
Take both of you. Issue notice. Returnable on 8th of January 2025. Steps
Now
be
the
taken.
premises under lock and key and the.
So what?
periscope are there.
Madam, better off you go, if you have closed it, close and get it done and then after that, you cannot continue. I'm issuing notice.
Withdraw
I'm not
it,
going.
withdraw it.
Withdraw it. Ms. M. Kumari, the learned counsel, appearing on behalf of the petitioner, submits that the petitioner would not like to press the petition application. Accordingly, the instant petition stands closed on withdrawal.
For information, Lordship, subsequently we have submitted 2 complaints. They are still running. Submitted a complaint.
That you know, there's an order, file content.
Please.
What happened?
Mr. Bora, kindly take steps. Because if they have not done it, finishes them, nothing. What is this?
It was related to receive non-payment of some contractual payment, Lordship, some part payment, Lordship. Lordship, the phase 19 is there.
They come for orders. Orders is
Admission
like,
admission account.
itu kupa ulale. Huh? Oh, he took time
Yes,
last item, huh? Then, why did you ask for time for these type of matters?
So, Lordship, I have some
Hello,
other
none is there.
accommodation, Lordship.
Please this matter again on 6th of December 2020.
Problem, Lordship.